Good morning, everyone. It's just after 9:30, so the inquiry's resumed. Just a few housekeeping matters, so perhaps I'll start first. Firstly, I said yesterday to Miss Murphy that I wasn't able to consider any more submissions about the Turner influence, and I know the case officer did get a couple of emails yesterday. As I said to Miss Murphy, as Mr. Bridgeland wasn't in the room, it wasn't fair for me to hear evidence on that particular aspect because simply the time slot had gone. So I won't be considering that particular aspect. Secondly, I have had a good look at the legal agreement, and I'm sure solicitors don't need to be present tomorrow.
Thank you very much indeed, sir. I think that's helpful. I think I will certainly be, although I know what you said of having already been through it, but I will obviously be in a position to take the inquiry through the operative parts of the document in accordance with that summary that we've agreed actually between ourselves and the local authority. So we'll do that.
Okay.
But that's helpful. Okay. Insofar as the program for tomorrow is concerned, we'll talk about the program for today in a moment, but the program for tomorrow includes a slot for the ecologist.
Yeah. I was, if I can interrupt you there, I was going to, you're obviously aware of the duty I have under Circular 0605. So it's focusing really, from my point of view anyway, on protected species. So I'd like to understand the nature of the surveys that have taken place and when and what was found. And then on that basis, how does the proposal deal with that survey information?
I'd understood that,
Yeah.
but thank you to get that confirmed is helpful.
Yeah.
I think we're conscious of having put in a report, an updating report in the Roberts rebuttal. So that's Appendix 4 to the Roberts rebuttal. And insofar as that updating work is, as you will of course expect, the circular is the operative parts of the circular are set out at page 8 of that note, and it's section 5 from memory. I'll just check it. Yes, which is probably particularly useful on the matters that you've raised. That begins at 16, page 16 of that report. So what this consultancy has done is it's reviewed the submitted information, it's considered the age of that against guidance, and then it's looked at the age and validity of the baseline ecological data at 18, and then cutting a sort of long story short, it then goes over to, there was a further survey undertaken. That's it. Do you see it? This is 516, refers to the initial work. There were 3, if you like, sets of survey work undertaken as set out in 516, and then there was a further at 517. And so if further detail is required in terms of sort of methodology or site area, I imagine I can get that produced, but it's helpful to know if that's the focus of it, then I can prepare the ecologist to, if you like, to come equipped to explain that.
If he could swat up on the what ECOSA have done in the past, so he's aware of that, because
certainly
appreciate it's
is.
a
I mean,
difference.
that was the point of the review, is to get to grapple with what they'd done initially, and then to decide whether that was sufficient, and then to undertake some investigative work. I mean, you'll appreciate, of course, that the council's position was that a condition would suffice to secure updating work, bearing in mind the findings of the original survey work. We've actually gone beyond that in getting this updating work to put before you, mindful of your duties. In terms of the sort of practicalities, that person has to attend remotely, please, and the council is organising the technology for that. Okay.
Yeah, good. Okay, I'm quite happy for him to appear remotely. I mean, it worked okay yesterday, so on the same basis we'll be fine.
If you're happy, that's great.
Yeah, that's fine. I mean, if it's easier to do a time slot tomorrow, I'm quite open-minded about that. But equally, I appreciate that might disrupt the flow of your examination and cross-examination. So I'll just put that on the table. And if you're Mr.
But I certainly see the sense of it.
If you, Mr. Grant, want to discuss that, how best to program it, then I'll leave that with you.
Thank you. Just then, in terms of, so that's looking ahead really to tomorrow. And as far as today is concerned, you'll have been conscious of two things which the party has been talking about, which would mean putting new documents into the inquiry. One is a correction of the correction, and the second is the material which underlies what Mr. Hall said about the council's growing strategy. We are doing our best to try not to disrupt the timetable, but in order to save a bit of time, I think overall we'd probably like you to start maybe just after 10 o'clock, or adjourn until, say, just after 10 o'clock, because we're not there yet. Not least because actually that allotment material needs to be introduced to the Rule 6 parties so they can consider whether they are happy for that to go into. Not just us, of course.
Yes.
Yeah.
Yes.
We are in a position now. I think I haven't seen it, so can I? Yeah, we'll do that as soon as we can, if that's all right.
Okay.
We'll say 10:05 work.
So I need a bit of time, as my learned friend was saying, just to talk the Rule 6 parties through those documents.
Yeah.
I'd need also, I haven't yet seen the errata to the errata, so obviously I need to take instructions on that.
Yeah.
So can we say half an hour? I think without trotting out a platitude, I think it's a time-saving half an hour.
Okay. Okay. Well, on that basis, we'll adjourn then. So we'll start at
10 past?
10 past 10. 10 past 10. Okay. Okay. So the inquiry's adjourned till 10 past 10.
Thank you very much. in a moment ready to move on. Can I just bring you up to speed with where we are on the two issues?
Yeah, so the inquiry is resumed. Yeah,
sorry, thank you very much. The first is, so far as the underlying material that the appellant had asked to see yesterday in relation to the makeup. Do you remember of the acreage? So you saw press release up to 27. Mr. Hall gave evidence the current figure is 15, etc. So far as those documents are concerned, which consist of a mixture of emails and spreadsheets, I have my learned friend has seen them, as have my learned friends for the Rule 6 parties. I think all parties are content for those those documents to go into the core documents. So no issues so far as that's concerned. As to how we deal with it, my learned friend for the appellant and I have had a discussion as to what seems to be a sensible and pragmatic approach to that, which is that you'll have gathered that the issue from the appellant's point of view, as I understand it, that it goes to is to the issue of a Grampian condition. And our proposal as a sensible way, I think, forward is that when we get to the conditions session tomorrow, which will be in a roundtable format, the council, probably me, will talk you through those documents. It won't take very long just to make sense of them.
Yeah.
And then that can form the basis of discussions as to substantive conditions, and then no doubt submissions in September.
Okay.
So that, I think, is how we propose to deal with that issue, subject to anything in a minute that my learned friend wants to add. The second point is, so far as the errata to the errata, we've got that, and I don't make a criticism, but I haven't yet had a chance to understand the detail of it or go through it with Mr. Hall. We only got it a few moments ago. But again, in terms of a sensible, pragmatic way forward, the route that learned friend for the appellant and I have in mind is that you'll have seen when I proceeded after the pause in examination in chief yesterday, I dealt with the point in terms of the principle. Yeah. And what we are going to the way I think we're going to look to deal with it is that when on that basis, I don't need at the moment anyway to reopen examination in chief to deal with it. My learned friend, I think, in cross-examination is going to deal with it on the basis of the principle. If having had a chance in the various adjournments to consider the detail of it, any of the parties consider that they want to return to the matter formally, then we would apply to you to do so.
That's fine.
But at the moment, I think we're going to endeavour to deal with it on the principles. So that is, I hope, on both points, provide you with two pathways that you find acceptable.
Yeah. Okay. Thank you, Mr. Grant. Ms. Murphy, can I
Yes.
assume that you're happy with that?
Yes, we're doing our very best
Yeah,
not to
yeah.
make a meal of it, but to be honest, there's quite a bit to deal with.
Yeah,
but
appreciate
we're just
that.
trying to
Yeah.
we're just trying
Yeah.
to park as much as we can.
Yeah.
So as not to disrupt the timetable.
Yeah. Okay. Right. So on that basis, Mr. Grant, you've finished examination of Mr. Hall.
Yeah, I've finished with the continuing caveat that I reserve
Yeah,
a decision if we need to.
absolutely.
But subject to that,
Yes.
I've finished, yes.
Yes. Okay.
So
Thank
can
you.
we just make sure that
Yeah.
the inspector has got? I think you've just been given the correction sheet.
I have, and that's been very promptly emailed. So
Lovely.
I've had that, and somebody's in Bristol to have passed that on, thankfully.
Good. That's great. So we're getting good support there. The emails and spreadsheets and so on, have they been circulated? No. Okay.
I think I suspect it'd probably be lunch by the time I'm able to have a proper look at them.
actually, that they require a bit of explanation. So I probably wouldn't, if you like, I probably wouldn't worry too much about that. I think it would be helpful. Our plan is for it to be introduced properly during the condition session where it falls, where it's actually relevant.
All right, then.
By all means, consider it. But
Yeah.
actually, Milan and Friend spent about 10 minutes explaining it to me this morning, and that was a profitable exercise.
Right. Okay. Right.
It'll be much easier.
Okay.
Yeah.
Okay. Perhaps that'll spare my digestion over lunch then.
Yes. Don't upset your sarnies.
Yes. Thank you. Okay, so I think we're probably ready for cross-examination.
Yes. Sorry, it's been a bit disruptive.
No. It's the way it goes, and appreciate there's a lot of various bits of information to pull together. So
Thank
no,
you, sir.
that's fine.
That's kind. So in terms, before we get going formally, in terms of the documents that we're going to need, Milan Friend helpfully gave you a list yesterday for examination in chief, and I think if you will have got all of those organised, I think that will probably do.
Okay.
Just as a reminder, that was the Hall evidence, obviously, the Roberts evidence, the Bridgeland evidence, the framework, the development plan so far as material, London plan, local plan, the open space study, which I think is E1, isn't it? And the allotment strategy, which is E3. So I think you're using all electronic documents.
Well,
like
I'm doing a mixture actually.
Oh, are you? Okay.
Yes. So I've got a mixture of the just some things are easier to find than others. So that's how I work.
Well, we'll probably get used to it, but I've got electronic page numbers in my notes,
Okay,
so
well,
I can give you those as we go through.
I can stick to electronic. That's fine.
Fine. And then the other core documents you mentioned were the previous decision, which of course we'd look at that, the asset community value judgment, and we'll look at the, of course, we'll look at the officer report too. That'll probably do for the time being.
Okay. Yeah.
And I think, Mr. Hall, you're on mostly electronic documents too. Good morning to you.
Good morning.
I'm going to ask you some questions to start with about allotments and about the duty to provide allotments. We'll start, please, with Hounslow's allotment strategy. And looking at your proof, if we turn to your page 19, you mention it there, helpfully give us a core document reference and indicate that it's an adopted document which carries significant weight in your view.
Yes.
Yeah. So that turn to that, if you will, please, which is CDE3, and when you have that, page 21.
Mm-hmm. 21. Yes, I'm there.
You'll see then that that's Appendix 1, legislation and policy.
Yes.
And it refers, doesn't it, to a statutory duty on local authorities to provide allotments in certain circumstances. You see that?
Yes.
Now, it's expressed in summary form, but Section 23 of the 1908 Act provides that if the council of any borough are of an opinion that there's a demand for allotments in the borough, the council shall provide a sufficient number of allotments and shall let such allotments. So if I were to ask you the question, who is under a positive duty to provide the population of Hounslow with allotments if there's demand for them, then the answer would have to be the council, wouldn't it? There's a statutory duty to provide allotments if it concludes that there's demand for those allotments, isn't there?
Yes, the council has a duty to provide allotments for its borough.
A statutory duty to provide allotments if they're of the opinion that there's a demand for it.
Yes, they have that statutory duty.
So to the extent that there's a shortfall in provision, allotment provision, the responsibility for that shortfall rests with the body on whom there is a duty to provide allotments, i.e. the council. That's right, isn't it?
The council does have a duty to provide allotments for its residents.
Not the answer to my question. My question was, to the extent that there's a shortfall in allotment provision, the responsibility for that shortfall rests with the body on whom there is a duty, i.e. the council. That's right, isn't it?
It does rest with the council.
Yes. Thank you. Now, keep CDE3 available, because we're going to come back to it. Go into your proof now for a moment. So page 46, please, your table 3.
I'm there.
Good. Table 3, I think, is identifying a shortfall in allotment provision looking at the demand supply position since 2018. Is that right?
That's correct.
Yeah. So a shortfall, for as long all the information that you've provided to the inquiry indicates a shortfall in provision for more than 5 years.
It does.
It does. And hence, one assumes your portfolio holder, emphasising that the council's been taking steps to address that shortfall by explaining that in the public domain that it's identified land and will be looking for developer contributions.
So yeah, the council is proactively looking to increase its allotment supply and has done several things towards that.
Yes, but the point that I put to you, which is specific, and I think you've agreed with it, is that it's been taking steps to address the shortfall by explaining that it has identified land and will be looking for developer contributions. That's right, isn't it?
That's correct, yeah.
That's correct. And we can see that, you're right to agree it, because we can see it. In Ms. Roberts' rebuttal, Appendix 1,
Appendix 1.
Ms. Roberts' rebuttal, Appendix 1, we can see that a press release, I think it was.
Yes.
Yeah, that was the 16th of November 2022.
Exactly.
So November just gone.
Mm-hmm.
And the claim there is that up to 27 acres of land had been identified in the first phase, much of which is currently inaccessible. And if you turn over the page to the second paragraph, the initial phase of Grow for the Future will look at unused council-owned land, but subsequent phases will assess unused and inaccessible private land that could be leased or purchased by the council and opened up to the public and schools as community spaces. So the initial phase focused on unused council land, is that right?
That appears to be the case, yes.
Okay, and so we should take it, should we, from all of that, that the council's intention is to fulfil its statutory duty to provide allotment land to meet demand pursuant to this strategy?
The purpose of this strategy is to help to tackle the demand.
Yeah.
It is not it's not the only way of tackling that demand.
But the purpose of the strategy is to seek to fulfil its statutory purpose, isn't it?
Yes, it's in line with that statutory purpose.
Indeed.
Yes.
Indeed. Now, not surprisingly, post refusal of planning permission by members, the appellant, in thinking about the Section 106 planning obligation, and completely without prejudice to its contentions about the need for any of this, and we'll come to all of that in conditions, it was looking for it was looking to investigate the scope to provide contributions. Now, you've set out reasons why you think that wasn't appropriate in 17.2. But of course, the council doesn't it? And it transpires, this is the case, have information about land, and it's been looking at the matter in some detail, isn't it?
Information about land.
Land in order to provide allotment capacity.
Yes, it's been looking at options for increasing capacity in line with that duty.
Yeah. Okay. Yeah. So we'll come back to that a bit later on in the context of conditions in that case. Now, I said we'd look again at CDE 3. This is the moment, and back to that appendix, if you would please. Note, will you, that there are.
Apologies. Which document is this again? Can you remind me?
It's okay.
The allotment strategy.
The allotment strategy.
All right. Thank you very much.
Is it E3 or E1?
I think it's E3. Yeah. Thanks.
And page 21 of that.
Yeah.
Good. So note, will you, that there are specific compulsory purchase powers under the 1908 Act for the purpose of providing allotments in accordance with the council's statutory duty. Do you see that?
See that? Yes.
So extant, if elderly, compulsory purchase powers there, but actually they're not the only powers which are available to local authority. If you look at Ms. Roberts' rebuttal again and go to the legal note appended to that, I think it's Appendix 2 to her rebuttal.
Okay, I'm there.
So we've got a few points to pick up in this. On the compulsory, we're going to take it in, it's slightly out of order, but on the compulsory purchase point, do you see page 4 and paragraph 14?
Mm-hmm.
Yeah.
Mm-hmm.
So under section 226(1)(a) of the Town and Country Planning Act, you've a planning compulsory purchase power, don't you?
There is that power.
There is that power. And back in the note to page 3, if you would.
Yeah.
You'll see the contention, the proposition of law, in fact, that not all land which has been used as allotments is the subject of equivalent levels of protection in either procedural or substantive terms, which is true, isn't it?
Yes, that's true.
So where you've got, and this is paragraph 11 then, this is distinguishing between statutory and non-statutory land, which is a term that you've used in your proof. So I know it's fair game, if you like, because you've understood that sufficient to include it in your proof.
Mm-hmm.
Whereas local authorities purchased or appropriated land, there are procedural and substantive protections for that land. So as far as the procedural protection is concerned, you can't dispose of that consent of the minister. And in terms of the substantive protection, you're not going to be able to dispose unless you're satisfied that adequate provision will be made for allotment holders displaced. So that's a high level of protection for statutory land. Yes?
There is a higher level of protection for statutory allotment land, yes.
And over the page at 12, where land is privately owned and has been used as allotments under license, it's not subject to that protection. And I have added there, hence the modern outlet community value application process, which delays sale. It's a sort of right to bid. We'll come back to that. Yeah.
Mhm.
Yeah. And I've suggested that the local authority can't achieve via development plan policy the same level of statutory protection as afforded by the Act. To confer that status and corresponding effects, land must be owned or appropriate pursuant to that Act. Now, are you able to help me by confirming that, or are you not able to because that's a point for the lawyers?
I would say that's a point for the lawyers.
Fine.
Yeah,
So you hadn't
pleasing.
appreciated that, had you not, when you wrote your evidence?
Apologies, I hadn't appreciated that.
That proposition that the local authority can't achieve via development plan policy the same level of statutory protection as achieved by the Allotments Act. Had you not understood that when you wrote your evidence?
I had understood the fact that a local authority could not, for a privately owned site, yes, it would be a different case where that statutory protection would not be in place.
It would make a material difference, wouldn't it?
There's a material difference between the level of protection that can be given to a statutory site versus a non-statutory site.
Yes, and you're not, but that's a different point. The point here I'm making is you can't achieve by development management policy the same level of protection, can you?
To my knowledge, no.
No. Okay, quite right. So, I mean, it's right, isn't it, then, that private landowners like the Northumberland estates are not under any positive duty to provide allotments, unlike the council.
Yes, that's correct.
Yeah.
They're not under that duty
Yeah.
necessarily.
And so if, as a body, one wants to insist on a positive land use, in other words, some sort of active land use, rather than prevent a change of use by development management, you must have control of the land, mustn't you?
Sorry, could you just repeat or rephrase that?
I don't want to rephrase it because it's a very carefully put question, but fine. I will by all means repeat it.
Thank you.
If, as a body, you want to insist on a positive or active land use,
Mm-hmm.
you've got to have control of the land, because you can't achieve some sort of positive and active use via development management. All you can do is restrain alternative uses. That's right.
So the landowner will have the control.
The landowner is in control.
Yes,
what happens on the
essentially.
land, save to the extent that development management can restrain alternate uses.
Exactly.
Right.
Yeah.
Right. So we agree that. Now, if you want to achieve control of the land, you can achieve that via private negotiation, can't you? You can negotiate to purchase it, for example. Yes.
Mm-hmm.
Yes.
Yes.
Yes. Or as a last resort, where there's a compelling case in the public interest, you can acquire it by compulsory acquisition.
Yes.
Yes. But neither of those things has happened here, has it?
No.
No. And so the council's position here is that it can resist a change of use from allotment, subject to some of the points we're going to be talking about in terms of the detail of your policies, but it can't insist, can it, on land being put to allotment use?
It can't insist on the land being put to allotment use, but there is a policy protected status of local open space on this site, which will not change regardless of the owner or the statutory nature or non-statutory nature of the site.
And of course, you and I are going to spend some time looking at the suite of policies which are applicable, so we can move on that basis, because the questions that I want to ask you now are not on that, but on the fallback, on the correct fallback. Now, I think it won't be controversial as between us that the fallback has the potential to be highly material in a planning case, doesn't it?
Yes, it does carry that sort of special legal status, fallback position.
So if one reaches a conclusion about a realistic fallback position, you're going to give, as a decision maker, you're going to give that material weight in the planning decision, aren't you?
Well, a fallback position in this case appears theoretical at best to me.
No. Sticking with approach, please, before we come to the evidence. If you reach a conclusion on the evidence about what is a realistic fallback, you must, as a decision maker, give that material weight, mustn't you?
Yes, it must
Yes,
be given
yes,
to your weight.
Okay. So we're going to look now, because that's a matter of law, isn't it?
Yes, it is.
Right.
Yes.
So we're going to look at some background then. And in order to do that, we need to turn up Mr. Bridgeland's rebuttal evidence.
I've got that.
And we're going in Mr. Bridgeland's evidence back to 1917. But for practical purposes, page 4 and 5.
I'm there.
And at the very bottom of page 4, when the land was first proposed for allotment use in a petition, the Middlesex Chronicle was talking about somebody who I think was from the, if you like, the equivalent, the forerunner local authority, Mr. Lobjoit. Several attempts had been made to get land for the purposes. This is allotment land in the vicinity, but they'd failed. It was all very well to say the land referred to in the petition was only used for grazing, but it must be remembered that it was let to a tenant, came under the description of occupied land. At present, the land was used for grazing one part of the year and for hay the other. The clerk stated he'd written to the Duke's agent inquiring as to what land was available, and then there was authorization to negotiate a lease, and then there was a successful negotiation, and that is the process by which the lease was entered into with the local authority, wasn't it?
Yes.
So it was, in other words, there was no element of compulsion. It was a just private treaty negotiation which secured a lease.
And that appears to be the case.
Yeah. Yes. I mean, one option is to come a bit further forward, which might help.
Yeah, there's well, several things. Perhaps I don't know if the council could look at the noise that's coming out of the microphones, if they could be turned up. And the other thing is there's an invitation to. It's a big room. So I mean, there's no reason why the chairs couldn't be moved forward. Actually, if you want, they don't have to be. They don't look fixed to the floor, and there's no need to spread out amongst the room. So you're all welcome to move the chairs forward, but it's quite difficult for a speaker to have to remember to speak up. Because it's yeah, that's because I've raised my voice actually, but my late mum-in-law always accused me of mumbling. So so it is very easy for a speaker to subconsciously lower their tone, and I know I do it. So please do come forward, but I don't know if the council can do anything with the microphones, because surely that's the purpose of the microphones. But by all means, bring the chairs forward. There's plenty of room in the room, and you know, there's no need to be scared at the back of the room. So thank you. Okay, shall we try and continue? Oh, okay. I've been advised by the council that, and I'm the last person to advise on technology, that there's some plus and minus signs at the left-hand side as we face it of the control panel. So I don't know if that's going to help or not. Oh, right. Okay. I'm sorry. I've been advised that this is the maximum, apparently. So as I said, it is difficult for a speaker to consciously raise their voice. So please, if you do have problems, if you want to come forward, then up to you. Thank you.
Now that might help a wee bit. And you'll have to put up the occasional bosh as I wallop it. All right. We'd gone back 100 years, hadn't we, Mr. Hall? And so we are going to just look briefly at figure 11 to Mr. Bridgeland's rebuttal appendices. And you don't need to spend, so when you're in his rebuttal appendix 1, you're going to find a series of figures. 10 and 11 we're going to alight on briefly in that. So go after the plat, there you go. And 10 is the report that he'd cited. 11 we just need to look at because we find there that the arrangement was a 7-year lease to provide allotments, wasn't it? So it wasn't a purchase of the land by the council, it was just a lease, and at that stage a lease for 7 years. That's right, isn't it?
Yes, that's right.
Okay, and then to take the story on, we must then go to Ms. Roberts' main proof, and within that to her appendix 2.
Yeah.
And to the 60s. When you're in appendix 2, if you go to the back of it, you'll understand, of course, that these estates are managed for the generations rather than the short term. And so, and of course, all the record keeping reflects that.
Yeah.
So look at the letter from Hounslow to the land agent, the estates office. And what the council was seeing, what the council was doing was approaching the estate to see whether it could purchase the land, wasn't it? Whether it would be prepared to sell the freehold interest in the above land to the council for statutory allotment purposes.
I can see that.
Yeah. So not using any compulsory purchase powers, but trying to acquire by negotiation in order to provide statutory allotments. Yeah?
Yes, I can see that.
Yeah. Now, the advice given to the Duke was contained in a letter of the 31st of July of 1969, which is at the beginning of that appendix. You've got to turn it sideways to see it.
Okay.
Yeah.
That's sorry, this same appendix.
It's the same appendix,
Yeah.
but it's at the beginning of the appendix.
Yeah.
Thank you.
That's me.
And it's advice to the Duke, 31st of July 1969. And it says, well, halfway down the paragraph, it reflects that I've just put to you, that there was an offer to acquire. So I wouldn't recommend the sale of the land at this present time, as you'd only obtain existing use value. I'm of the opinion at some future date you should be able to obtain planning consent for flat development on this area, which would then very much enhance the value of the land. So because of its, in light of its development value, the advice was don't sell it. And duly, that advice was followed. And the letter that reflects that is the 5th of August, 1969. So And then just to complete this little bit of the history, if you look over the page, again, we're still in sort of landscape at 17th of February 1972. There was concern even as far back as 1972 that allotments were not being worked to their potential. Yes?
Mm-hmm.
Yeah. So what then happened, we can see in Ms. Roberts' main proof of evidence. Whoops, let's move that out of the way. Paragraph 2.5, please.
Mm-hmm.
And this is just narrating this more recent history, that the land had been managed on behalf of the council by private contractors while under lease from the estate. The estate resumed control and was not then prepared to grant further licenses. And we'll look at that little bit of history in a little bit more detail later. But the licenses expired in September 2021, and there's been a refusal to grant any further licenses, hasn't there?
It has.
That's all correct, isn't it, what I just put to you?
Yes,
Yeah.
that appears to be correct. Yeah.
Yeah. If we want to understand the extent of cultivation over time, we can look to Mr. Bridgeland's rebuttal appendix 1. And this is after the Chronicle extracts we were looking at. We've got an aerial view of the site in figure 12.
Yep.
Do you see that?
Yep.
Just making sure that there we go. And it's worth just pausing for a moment to consider that. Insofar as tree cover is concerned, which is, there isn't really tree cover in the allotments at that time, is there?
No.
And B, you can see very efficient use in the sense that you can see high levels of cultivation. It's very organized.
Mm-hmm.
Yes, almost every square inch of that site is under cultivation, isn't it?
That appears to be the case from the aerial image, yes.
And it doesn't. The reason it doesn't come as any surprise to us is because we know about that we're bringing to this photograph our understanding of Dig for Victory and the war effort, and so we know that when you want to make it use of that land efficiently, that's what it looks like.
Hmm.
Yeah. And by contrast, we've a photograph from 2015, which is when the estate took back the management of the land, helpfully produced in your within your proof, page 33, please.
I'm there.
So page 33 of Mr. Hall's proof. And the top left image is figure 3, which is the aerial image of the site in April of 2015, which we can take as a reasonable proxy for the time at which the estate took over the management of the land, I think.
Yeah.
Yeah. And having seen a very highly cultivated picture before, we can now see that much of the land is treed, but also looks to be uncultivated.
That's in which figure?
Figure 3.
In figure 3, it looks to be fairly cultivated still.
All right, so there's a difference between us, and that's something the inspector can look at, albeit at a scale which is, fairly small scale, but one can judge that. There is also, though, helpfully for us, a design and access statement survey, which is at CDB1. Now, I don't think we necessarily need to go to it. I don't think you're doubting the veracity of the survey. I mean, they've noted down what's cultivated, what's uncultivated, and what's vacant.
The survey is not particularly thorough. It doesn't show any of the sort of underlying data. It's quite sort of a high level overview, and I think it would have been helpful at the time to see that what the kind of background evidence that had gone into that survey.
I understand the qualification, but you're not suggesting, are you? You don't have any better evidence. I mean, we've got material which shows on the basis of a survey what was cultivated, uncultivated, and vacant, and you're not suggesting that that's wrong, are you?
Well, London Borough of Hampton, we don't have any evidence that would sort of overcome that or trump that. So no, that's the only evidence.
Or indeed contradict it.
Or contradict it
to
date. No, yeah,
No.
not as of that time.
No. So the best evidence that we've got as to what was cultivated, uncultivated, and vacant in 2016 is the design and access statement, page 62, 2016 survey, which Mr. Van put up on his screen in his presentation. We could turn it up if you like. I was only trying to take it the quick way, if you like, rather than the short way.
So, sorry, are you referring to the allotment survey that's been undertaken by the appellant 2017 to 2021?
If you go to the design and access statement, you'll find that at CDB1. And if you're at CDB1, go in it to page 62.
62.
Yeah.
Sorry, a bit of a slow document.
Yeah.
62. I'm there. Yes.
Thank you very much indeed. And you'll see that the 2016 info is at the right-hand side. So it doesn't go early to late. It goes late to early, doesn't it? Yeah. And so you've got, as I put to you, based on survey data, which you've said you've not seen, and the inspector will understand that qualification. But what we've got from 2016 is what's cultivated, what's uncultivated, and what's vacant.
Yes, that's a sort of representation according to, obviously the appellant. That's the appellant's presentation of the position. Yes.
Yeah, indeed. Okay. And so we can see that there is actually a substantial amount of uncultivated land and a substantial amount of vacancy.
As at the time of this 2016 survey.
Correct.
However, obviously we can't verify that, and I think it's also just worth probably picking up on paragraph 12.8 of my proof, where I refer to, at the time of the initial asset for community value listing for the site in 2015, there were only 11 vacancies, with 78% of the 49 identified plots identified as being occupied. So at the time of that, which was just a matter of a year before that 2016, it seems quite striking that 78% of that site was identified as being occupied, whereas in the figure in the design and access statement, it does show quite a few vacancies. So there is a bit of a I don't know if that would have happened in such a short space of time. That's all I would question.
Well, I don't know how carefully you've looked at the 2016 data and what's shown on this drawing, but what was suggested during the ACV proceedings was that there were 11 vacant plots. I mean, it depends whether one thinks that has to refer to wholly vacant plots or not, but actually there are, I think, about 11 wholly vacant plots shown on this. It's not that different. I mean, as I say, it rather depends on whether you mean, each tiny sub bit being vacant, but there are 11, certainly there are 11 full plots vacant here. So anyway, it may be that that's not, in a sense, not that different. But we'll turn to the ACV judgment in a moment. Just one point though. My understanding is that the site visit was the allotments were quite busy at the site visit.
That's correct.
Right. Yeah. That's not typical, is my understanding.
I mean, I don't have a clear understanding of that. I haven't visited the allotment site many times.
No.
I've not seen it, especially during the summer period as well, where allotments do tend to be busier.
Okay. So turning then to the evidence that we have about the fallback position, if we look at your paragraph 3.3,
Paragraph 3.3 of my proof.
Your proof, yeah.
Of my proof, thank you. I'm there.
And I mean, we've got to this point already, but you'd said here, most of the way down this paragraph, that plot holders had been granted short-term licenses on expiry in 2021. The estate declined to renew. And so just reflecting on that, since the ACV judgment and since the previous inquiry's decision letter, there have been termination of the licenses and a refusal to issue new ones, haven't there?
Yes.
Yes. So that's a change in circumstances since the previous decision letter, is it not?
Yes, although I think there was already a climate of uncertainty at the time of the previous appeal, caused by the short-term licenses which have operated since the handover.
Well, in context, you and I have just looked at a situation in which there have been development aspirations on this land for 50, 60, 70 years, which have been pretty open, haven't there? So there's been some uncertainty for many decades, one might say.
Yes, although I would argue a more acute sense of urgency, given the fact that obviously the ownership had passed back into the hands of Northumberland Estates in 2015.
Okay, so if we turn then, I think, to the previous decision letter, which is CDF1.
Yes.
And when you have it, we will go straight to paragraph 48.
I'm there.
That previous inspector, we won't read it all out. I mean, obviously our inspector will have, am I going to be so bold as to suggest already studied it? I'm not sure, but you certainly you will do if you have already done it. I would too, sir, I would too. But the previous inspector, I needn't labour this because, of course, we've all read it, we've all formed a judgment about it. But my proposition to you is that he's dismissed the prospect of a fallback being no active allotment use, because he's said it's a theoretical possibility could, but he's doubted it, hasn't he? He said, well, I can't understand why the estate would choose to do so. So he's essentially dismissed that. a theoretical possibility, doesn't find that that there's a real prospect of that. So he doesn't actually give that fallback material weight. That's what's happened.
Yes, he doesn't. He doesn't give the option.
Yeah.
Much weight. No, any weight.
But of course, you and I have agreed that things have changed since then, because as a matter of fact, they've terminated the licenses. I think there's a dispute about whether that was effective or not, or they've attempted to terminate the licenses, but we'll come to the legal position on that much later. They've refused to issue new ones, as you know. In terms of the access at the moment, it's unlicensed.
It's
because they don't have the benefit of licenses, so it's unlicensed access, isn't it?
yes. So it's sort of currently the situation is it's more of an informal ongoing use, but that has been allowed by Northumberland Estates.
Well, it's been allowed on a specific limited basis, which has been explained in correspondence, which later in the inquiry, not with you, I don't think, but we can come to it. The estate's allowed unlicensed access on a specific limited basis, which is pending the outcome of this appeal.
Okay, yeah.
And the stated intention, which you've already heard and will be reiterated, is that the estate would be advised to continue that approach. So in other words, if planning permission were to be refused, that position of allowing unlicensed access would cease.
That would be the landowner's prerogative.
It is the landowner's prerogative.
But I do see no valid reasons why. It's a theoretical situation still. I maintain that as per the previous inspector.
Yes.
And I still see no clear reasons and good reasons why he would choose to do that.
So let's take this in little stages, because there's a dispute between us about this. The first point is you accept as a matter of fact that the stated intention is to continue a policy, the policy that's been set, which is to bring the allotment use to an end if planning permission is not granted and the existing allotments can't be relocated. That's the stated intention, isn't it?
The stated intention of
the estate, the appellant.
I don't think the estate has actually at any point made clear that it is their intention to do that.
Those are my instructions.
The option has been floated that could be an option, but I don't think we've ever been made clear about that in either the rebuttal or Miss Roberts' rebuttal, or indeed in her proof, that is the landowner's definitive, what he's definitely going to do. I don't think we've had any confirmation that is exactly what he's going to do as soon as the planning permission were refused in the event that happened.
That is the landowner's intention.
Well, we have not seen that in a clear and categorical way. We've seen the option floated, but we've not seen it definitively set out.
Well, I appreciate you hadn't understood that, but I set it out in my opening. Those are my instructions. We can hear as much about that as you wish.
Okay, noted.
Okay, supposing that that's the case, as I'm putting to you, that's the first point, is the stated intention. The second question that you raised then is, why would they do that? Let me help you with that. Why there's a real prospect of no active allotment use? Because it's a private landowner, first, yes, with no duty to provide allotments, yes.
It's a private landowner with no duty to provide allotments.
These are non-statutory allotments.
That's correct.
The private landowner has had development ambitions for the site quite openly for more than 5 decades, as we're going to see.
They have done.
They've refused to sell the land as allotments. You've
I don't know.
Seen it.
Oh yeah, they have refused. Yes.
There's been no attempt to compulsorily acquire the land, no expressed intention to do so. It's not even a possibility, is it?
There have been no attempts to compulsory purchase
the land. It's not even a possibility. There's nothing in your allotment strategy about compulsorily acquiring land to provide allotments, is there?
I don't believe there is, no.
No. And there'd be plenty of alternatives. So you would hardly get a compelling case off the ground, would you? Because you've given us a schedule of alternative sites. So how could it be a compelling case in the public interest to compulsorily acquire?
Alternative sites, sorry.
To this site, how could you say we need to acquire this site in particular when you've just given us a schedule of umpteen sites of
This is
alternate
the
allotment
reference to
sites?
the growth for the future.
Yeah.
Yes, although I
Yeah.
would caveat that in saying that a lot of the sites on those lists and those schedules are not purely for allotments. They can be for other community growing, small things, orchards. They can be strips of land at the side of
Yeah.
the verges and
I'm
things
not
like that.
running a CPO inquiry, but it's evident that there are a number of alternatives, even if you discount quite a few in your schedule. So you're not going to get off the ground on that. And the owner of this land has identified, hasn't it, that the ongoing tolerating of active allotment use is reducing the prospect of development. Quite an important point for us is that it is that ongoing use is regarded bluntly as having an effect of sterilizing the development potential of the land.
The ongoing use, I mean, well, the ongoing use is consistent with the designation as local open space.
Do me the courtesy of answering my question.
Sorry,
I mean, the owner has
restate
identified that ongoing use, active allotment use, reduces the prospect of development, of planning permission being secured. Shall I'll come to explain why that's so.
Yeah, if you may elaborate that.
Okay.
Thank
So
you.
we put part that for one side, but part that for the time being, I'll come back to it. But the landowner's been good at its word. I mean, despite the unpopularity of the decision with those who've had allotments on the land, it's refused to grant new licenses, hasn't it? And that's been unpopular. It's faced pushback on that.
That's correct.
Yes, but notwithstanding that, it's refused to grant new licenses.
It's refused to grant new licenses.
Right. Yeah, and in a property-owning democracy,
yes,
there is no obligation on a landowner to lease or license land in their ownership for any particular purpose, is there?
There's no obligation, but it's a responsibility, or
Sorry,
I would consider it to be, well, in this case, a civic responsibility on the landowner and a sign of good, stewardship. And
there's plenty of ways you can use land which are consistent with your civic duties and good stewardship, which don't involve licensing it to local people for allotments, aren't there?
There are other uses, yes.
Yeah, so there's alternate uses to which a private landowner can quite properly and responsibly put land without licensing it to other people. Can't they?
Yes.
Yes.
Yeah, that's a fair point.
And indeed, you can't second guess what someone is going to do. You must look at what they say and what they've done. And if there's no evidence to the contrary, then the only conclusion open to you rationally is to accept what they say will happen is likely to happen.
We can accept that it's likely or possible to happen, yes.
Yes, yes. And we are dealing with likelihoods, as you've suggested, because the situation here is that planning permission may be granted on appeal. We hope it will be, or it may not. But of course, it's a matter of the inspector, isn't it?
Mm.
Yeah, and we'll come to the importance of that in just a moment. In fact, let's do it. Let's do it now. I want to ask you some questions about GB8.
Could I just briefly, just before we move on to that, just say that, I mean, add to the reasons why, to kind of come back on those reasons that you've set out about why Northumberland Estates might choose to cease that use. Just to draw attention back to what I said in my evidence in chief yesterday.
You don't need to repeat your evidence, though, Mr. Hall.
Yeah, okay.
You only need to answer my questions. That's the point of this exercise.
All right. Okay, noted. Thank you.
And if I've been unfair to you, you'll hear all about it in re-examination. So can I just inquire how long do you want me to go? We've had quite a long, sort of big delay at the beginning.
It's up to you. I don't want to interrupt your flow.
No. I just want something, a time to aim for, to hit as a break, because I'm certainly going to go longer than that. But
generally, an hour and a half, I think, is a fairly sort of substantial section. But plus or minus, up to you.
If I was to aim for a break at around about 11:30, how would that work? Perfect. Okay, great. So GB8 then. Mr. Grant took you quite properly to the statement of common ground on that matter. And in that context, I need to ask you some questions about how that should be dealt with.
Mhm.
The policy itself, let's have that up. CD D8, so part 1 of the local plan.
There.
And page 171 of the electronic copy. Oh no, hang on, that can be right. Yes, 171.
And there.
So are you there are you at the same?
No, sorry, bear with me.
That's okay. 171 of the doc. Right, before we sort of get digging into the policy, just looking at the division of labourers between your policies. As I have understood it, GB2 is referable to land and GB8 is referable to use. Yeah, because if you like, you're not double counting an objection here, as I've understood it. You are saying there's, if you like, one and the same objection, they're interlinked, two different policies directed to two slightly different things. Where I get use from is if you look at 716, it seems to be focused on use. Yeah?
Yeah.
Yeah. And again, our approach in the actual policy text itself, again, referable to use. Our approach, GC, is to encourage the continued use.
Yeah.
Yeah. And so when one's reading the operative part then of the policy at A about retaining the existing allotments, that is about retaining use, isn't it? I think that's the only way of reading that sensibly to make everything all sort of knit together properly.
Yes. Yeah, I think that's
right, isn't it?
Yeah.
So, okay, and so then we've got a sort of logical problem on my case about this, because you've got two alternate scenarios arising here. Admittedly, on my case, so supposing my case is right about the fallback, and I, all of your points which you've written in evidence and said in evidence in chief the inspector's got, will understand, will think about it. But supposing my case is right on this, you've got two alternate scenarios. Scenario number 1, the planning permission is granted, in which case you've got the transfer of allotment plots. So your meanwhile use, which is the temporary unlicensed access, because it's pragmatic, because what might happen is you want to transfer from one place to another, that's been a sensible strategy, and that's what happens. Then you get 38 new plots and you get the transfer. So that's scenario 1. Yes? So I'm putting to you what are two alternate scenarios. That's scenario 1. Scenario 2, no planning permission, in which on my case as to the fallback, there's no ongoing use.
Yes, in your position. Yes,
so
exactly.
In reality, when one's talking about, in inverted commas, the existing use of the allotments, one's talking about a temporary use. So there's a sort of logical problem, because you can't retain a temporary use. It's inherently temporary. So the policy's got nothing to grasp onto in terms of use on my case. Do you follow me? So although what's set out in the statement of common ground is sort of factually right, it's not a meaningful concept here when we're talking about allowing a meanwhile use pending the outcome of a planning appeal.
Yes, I suppose in your case that's fair, and I suppose that's something for the inspector to pick up on. So
Yes, so there's the fork in the road between us, you see, is that the sort of theoretical application of GBA is one thing, but when it comes to actually grappling with what we're saying, quite another. And I think that's the reason why we've got a difference between us about, obviously not the relevance to GBA, but about whether it makes any difference. Do you follow?
I follow, yes.
Okay, thank you. Now, I said I hope not speaking out of turn, but try to assist with the matter of why you would not why the estate's not prepared. Its advisors are suggesting that you essentially sterilise the development potential of the site by continuing allotment use. It's because of the way in which the council has approached matters. So if you look at CDE2,
Yeah.
and when you have CDE2, the first thing is that it's an open spaces background paper, so it's, I assume, subject possibly to updating. It'll be used as part of a plan process. Yeah, so
Yes.
we know it's what it's for. And within it, page 26, please.
Sorry, it's jumped. 26, right, I'm there.
So page 26 of CDE2. We've got a heading at the top, local open spaces proposed for development.
Sorry. 26. Sorry, I was just
That's okay.
navigating onto the right thing now. Don't know the wrong one. Sorry, yes. So so local open spaces proposed for development, yes.
That's it. And at 8.1, the plan reviews are proposing to release 4 designated local open spaces for development. 2 of these are former allotment sites, and the following section provides a justification for releasing these sites. So in other words, if one wants to understand what criteria the council applies when thinking about whether release for another land use is justified, this is a good guide, isn't it? Because that's what it says.
Yeah, well,
Yes.
yes, exactly as in this sort of review document.
Yes.
It looks at
Yes,
those
I mean,
sites.
this isn't something which you've said is the council's rejected as an
No.
outrageous
No.
flying in the face of normal approach or anything. I mean, this is part of your evidence base, isn't it? Yeah. Okay. So the starting point is that the borough doesn't currently meet the standards recommended by the National Society. That's at 8.2. And then it reflects on waiting list figures and again finds, I think, more people wanting allotments than there are allotments, which is not a controversial proposition as between my client and your local authority.
Sure.
And then at 8.5, the study finds that there are 2 sites which are currently unused but are known to be former allotments, and 1 further site understood to be not in use. Now, as a matter of fact, the Green Lane site and the James Street site are both owned by the local authority, aren't they?
They are.
Yeah. And it's green. Just take Green Lane as an example. It hadn't been used it's the longest period of non-use. That was 30 years, but the other one was 20. So non-use, the fact that something's not been in active use, has been the starting point for the study in deciding whether or not release is justified.
It's been one of the starting points, and also the sort of identified lack of interest in those sites historically.
So not used, And then classification is then also important. So inaccessible natural space. So because, and we'll come to this a little bit later, but when you're thinking about open space, there's a sort of hierarchy, isn't there? The more purposes that open space serves, the more valuable it is, all other things being equal. So you've got accessible natural space, it'll be more valuable than space, accessible, if you like, and providing a visual benefit will be more important than space which just provides a visual benefit, all other things being equal, because it's performing more open space functions.
Yeah, most likely. That's
it.
yeah.
So it's not a designated statutory allotment. Again, that too is material.
Those are not, well, yeah, they're not statutory.
They're not statutory allotments, and that's been taken into account. So just in summary then, when thinking about criteria for de-designation, non-use for a period, and we can, I think, probably agree, you and I, that it's mindful of the need for housing, because that's what they're going to be allocated for. Yes, is that right?
Yeah.
And even where...
Well, not necessarily housing, but it can be other, because I know that the Green Lane site, well, for instance, the planning permission that was granted back in 2004 was for industrial site.
But maybe I'll put the point more neutrally in that case. I'm quite happy to put it more neutrally, that it will have regard to other development requirements which are at the time of the decision pressing.
Yes.
Yes, okay. And a whole range of other land use considerations, including transport sustainability and so on. Yes. And even where demand for allotments exceeds supply borough-wide.
Even, yes, so, yeah.
Yeah, okay. So bearing in mind those factors, periods of non-use are obviously highly material to a decision to accept the de-designation of land as allotments.
Periods of long-term substantial non-use.
Yes. Well, the state operates on a long-term basis, and it can only make decisions in the moment. But you and I agree that non-use is one of the factors that the local authority will consider in deciding whether or not to, for example, allocate land for example, housing.
It's one amongst a host of reasons, yes.
But it's an important one, isn't it?
I think all reasons are important that go into the consideration.
Okay, all right. Well, you quibble with that, but you will accept that the appellant is entitled to conclude that that's an important reason, and that wouldn't be unreasonable.
The appellant can come to what conclusion
perfectly reasonably can come to that conclusion that it matters, can't it?
Yes, but I don't know if they can necessarily give that reason more weight than other reasons that might go into the allocation.
Well, that'll be for them, won't it?
Well, they can make that judgment.
They can make that judgment, and they have.
That's fair.
Okay. So just thinking about how the council could have changed that basic factual position had it so chosen over time. Since the council had originally sought to secure allotment use of this land, it's been within the council's powers to compulsorily acquire it for allotment use, but it hasn't done it, has it?
No, it has not.
No. And since at least 2018, there's been unmet demand in this sub-area for allotment plots. That's right, isn't it?
Yes.
Yeah. But now, apparently, the council is seeking, is it, to insist on a particular use, but without the normal compensation which would be payable for permanently securing a positive use, which isn't financially viable to a landowner, but is a planning benefit. That's what the council's wanting to achieve, isn't it? Is active allotment use on the site, but without the payment of any compensation, without securing it via negotiations.
The site is currently in allotment use, and yeah, the aspiration is for that to continue. And it's for the landowner to maintain that.
Well, essentially what you're doing is criticising the Northumberland estate for not continuing to provide allotments pursuant to a duty which is in fact owed by the council to the residents of Hounslow, aren't you?
I think the point needs to go back. The fundamental point is that regardless of the allotment use, it is local open space, and that designation does apply.
We'll talk about local open space in a moment, but I'm not at the moment, as you know, I'm asking about allotment use, aren't I? And of course, you can impose development management policies which are negative in nature, but they can't of themselves, as we've agreed, secure actual use as allotments. They can't do that. You've got to control the land. We've agreed that.
Yes, we agreed that.
Yeah. And so then if we go back to your 17 point, sorry, I misread that. And I do that with numbers, by the way, just so you know.
Numbers.
I misread numbers sometimes. So
that's
a bit
fine.
of patience required.
That's fine.
12.72, 12.72.
Of which?
Your proof?
Of my proof, 12.72.
12.72.
Thank you.
And this is really just tackling what you're saying, that you say we float the threat that in the absence of planning being granted, the existing allotments could be closed at any time with the appellant. It's not, I mean, the position is much more concrete than that. It's that having identified that the development potential of the site is materially affected by the ongoing allotment use, the advice to the estate is that that should be brought to an end if planning permission has not been granted, and that you can expect that that policy would continue, having been initiated by bringing licenses to an end and not granting new ones. Now that is our position. It's not a threat. That's an analysis which we present to the inquiry, and having regard to the open spaces study, that's not unreasonable, that analysis, is it?
That analysis is not unreasonable, but I still see no clear reason why that would happen. And I think, if anything, there's less prospect now of that allotment use being ceased should this appeal be dismissed, because both of the, both options for development of the site would then have been dismissed.
No, that's not correct at all. I mean, I don't want to argue with you. Maybe that this is one for submission, sir. It may be that you've got the. Yeah. Okay. Thank you. That's helpful. And just before we finish, because I know we agreed at 11:30. Whatever about what we don't agree, what we do agree is that there's no secured allotment, active allotment use at the moment, because of all of the range of things we've been talking about. We can agree, can't we, that the grant of planning permission via the Section 106 planning obligation does in fact secure allotment use, because it makes over 38 plots, which are serviced plots, if you like, they're oven ready, and it secures that for a period of 50 years, doesn't it?
Yes, it secures a re-provision.
Yeah, and what it does is it makes provision for an allotment management plan. So if you like, outside the heat, if not light, of the adversarial process, there can be a more collaborative approach to the management and provision of new allotments, can't there?
Yes.
Yeah, and so that's what secures active allotment use, is the Section 106, and that only gets comes to fruition if planning permission is granted. Correct?
Yes, that process. I mean, yes, that's the only way that's the appellant's way of doing that. But obviously, they could go about that allotment management on their own prerogative. But
but what we're saying is
your position is not going to happen. Yes. Yeah.
Thank you. So that, sir, is a good moment to stop. Thank you.
Right, we'll adjourn 15, 20 minutes. Well, let's say 11:50 we'll resume. Thank you. So, Mr. Hall, needless to say, in purdah. Thank you. With continuing cross-examination of Mr. Hall.
Thank you very much indeed. The next topic is a related one, which is we've been talking about the Section 106 planning obligation and the provision of plots. And I used the phrase sort of oven ready, and I think you recognise what I meant by that. But we just need to look a little closer at the facilities which are proposed, however briefly. Now, the first thing is that it's investment of whatever scale we're talking about, whether it's small scale investment, one or more water butts, or larger scale investment, but it is investment, isn't it? It's the application of privately owned land for publicly beneficial purpose.
Yes, it's
Yes,
investment.
it's investment. It's investment of land, but it's also then financial investment as well in terms of the provision of various facilities. And we're just going to come to look now at the extent to which those can be regarded as beneficial, and if so, to what extent. But it's all investment.
There's investment, yeah.
Okay. And one of the things that might help is that your council's allotment strategy has looked at the sort of facilities which are commonly helpful, and that's in a more sort of depersonalized context. It's not an adversarial context. So that's something which is helpful to look at, isn't it, in order to identify whether particular facilities are helpful or not. But we'll start with the personal. And in order to do that, if you look at, please, the design and access statement again, so that's CDB1.
Yes.
And within it, page 81.
Yes.
I'm sorry, just looking for my reference. Oh yes, sorry, I can't see for looking. The consultation response, do you see you've got proposed layouts and then you've got response? My understanding is that there were 19 attendees to the consultation, and they provided, in addition, I think there was some email contact with either the same or other people, I don't know. And then this, allotment holders responded well to the reflection of existing landscape character, with option 1 providing a preferred layout to further explore. They highlighted a desire for sheds to store tools, garden benches or picnic tables alongside defined composting and better water connection points. So, I mean, as I've understood it, they wanted sheds, wanted defined composting, wanted better water connection points. And so to the extent that you can provide that for those people, that is beneficial.
They're beneficial in that, they are providing, they are extra investment,
Yes.
but the amount, the weight that can be given to that is, a matter for dispute.
Well, yes, okay. But it's not that these have been foisted on anybody. They were sought and have been provided in order to meet what was asked for.
Those are things that some for survey respondents may have raised. Yeah,
it's not unreasonable as an approach to say, what would you like? That's what we would like. There you go. I mean, that's not an unreasonable approach, is it?
Yes. Yes, although obviously the specifications of what has been provided, the quality of those and whether they're effective for the future use of the reprovided allotments is a question for.
Okay. And then in terms of, there's been some questions, I think, about the communal facility. Just to touch on that very briefly, the third paragraph of the allotment design on page 82 refers.
Mm.
I'm not sure. I think I'm going to ask you a question that I don't know the answer to. So I'll put my tin hat on. Are you an allotment man?
The allotment plan.
Yeah, are you allotment man, Mr. Hall? You have an allotment.
Am I an allotment man? No,
No,
unfortunately
no,
not.
okay.
Wish that maybe I will be one day.
Right. Okay, all right. Great social benefits, I understand. I'm not being glib. In all honesty, the communal shed is in part a facility directed to bringing people together.
Yes.
Yes, and actually, the evidence that we've heard so far has given particular emphasis to that social benefit, hasn't it?
Yes, although we have also heard that the social element happens even without that benefit.
But providing a focal point is no bad thing, though, is it?
It's no bad thing to have a focal point.
Okay, all right. Now, in terms of so I need to take you to one reference. Just take a minute. No. CD, I want to ask you a little bit about plot size, this being a bone of contention with the current plot holders or those who are having unlicensed access to the site at the moment. If you go to CDE3, please, and within it, we'll start at page 12.
Okay.
Do you have that?
I have that, yes.
Thank you so much. So, when we're thinking about plot size, one of the matters which can be taken into account is that allotments which are too big pose a barrier to entry, don't they? So if you look at your document, the council strategy, barriers with allotments, the main barriers mentioned by participants were time, waiting lists, in other words, they can't get onto the plots, plot size, or lack of confidence. Now, that is about not wanting to take on allotments which are too big, isn't it?
Yeah, in some cases of people.
Yeah, yes. Because we live in a very time-poor society, don't we?
Yeah.
And you don't want to take on a responsibility that you can't honour, that you can't fulfil.
Yeah, I mean, it depends on the individual.
It very much depends on the individual, that's right. But in other words, specific groups of individuals won't necessarily reflect the wider community. Yes. And so what's not being said here is that the bigger the better. Actually, when survey people have been asked about plot size, the concern has been about ensuring that they're not too big.
Yes, in some cases, people have concerns about that.
And still thinking about plot size, if you go down to the theme 3, page 18 section of the document.
Sorry, which page, sorry?
Page 18.
18.
Yeah.
Yes, I'm on page 18, theme 3.
And it's not just to encourage take-up that you might look at split plots, but also to give more people great access to plots. Yes, if you look at review of management of waiting lists, so it's not just here that you'd be looking at providing smaller plots. It's that more generally that may be necessary in order to reduce your waiting lists.
Yeah, it's
because
one way.
You'd look at the waiting list, you say, well, we've got our plans in place, but we want to ensure that we give the maximum access to people, and that's legitimate, isn't it?
Yeah, smaller. If the site is carved up into smaller plot sizes, there's potential for more people to have plots.
Yes. So, I mean, there's a sort of, of course, the real enthusiast will want the biggest space possible, but you and I will know that people can grow things on a balcony, on a patio, in a small garden, and a 60 square meter plot is considerably bigger than any of those.
It's larger, but it's still, considerably short of the national recommendation, which is 250 square meters.
A national recommendation is not adopted by your council for any particular purpose, is it? It's just a particular interest society's approach.
Yes, although it is based on people who know a lot about the subject and who have consulted with allotments holders across the country.
So, but what we know is that that's not a national standard, is it? The government hasn't adopted it.
It hasn't been adopted.
Planning
No,
it's got no status.
Not enshrined. No,
it's got no status for planning purposes, has it?
For planning purposes, no. It's guidance and that.
Yes,
that's it.
And so when we look at what you say in your proof at 12.60. A couple of points. One is that there is actually variation in terms of the size of plots proposed. They're not all uniformly single. There's actually, 21 square meters difference between the smallest and biggest, isn't there?
There is.
Yeah. So they're not regimented in quite that way. And in terms of whether somebody who you're terming a beginner would want to move on to a bigger plot or not, that's not reflecting, is it that many people who are experienced allotment holders will be quite happy to have a plot of 60 square meters?
I'm not sure if they would.
Oh, right. You're not sure about that. Well, we can ask a little more about that later in the inquiry if that's not something you can help with. Okay. We're going to now move on from that to the subject of open space. And within, I think we should turn up the local plan on this to GB2, please.
I'm there.
Thank you.
If I might just circle back just very briefly, I'm sorry to interrupt on that, but just on the point of plot sizes and not being able to help out on that point, I think it's worth drawing attention back to the statement of community, community involvement. Yes, where it was found that the majority of plot holders wanted plots of the same size as they currently had.
Doubtless.
That indicates,
doubtless, because the people who are currently enjoying unlicensed access want to maintain the status quo, don't they?
Well, yes, it indicates that a 60 square meter plot would not be adequate.
No, it doesn't. It doesn't indicate that at all. It doesn't give us any clues to adequacy. It just tells us what their preference is.
It indicates that the larger plot sizes that exist on the site in the current situation is what plot holders want for the foreseeable future.
Exactly. They want the status quo. Thank you. Okay, so GB2 of the local plan. We've agreed that there's a sort of hierarchy of value in the sense that the more functions a particular part of open space provides, the greater the value, all other things being equal. And that's obviously logically correct. If you look at a couple of places within the explanatory text, sorry, that's a bit too close, I think now. 7.4, you can see emphasis given to different functions. Yes?
Yes.
And of the different functions, contributing to recreation is important, isn't it, for the health and well-being of borough residents? And so evidently the council gives emphasis to that.
Mm-hmm.
Yeah. And in order for that, for open space to have that particular benefit, it's got to be publicly accessible, hasn't it?
Yes, in order to
Yeah.
provide that particular benefit.
Yeah. And same point goes for that particular function in 7.6. So what we can agree then is public access is important in terms of attributing a value to land, and where land is accessible, the open space is more valuable, all other things being equal, than when it is not.
Yes, I think
Yeah.
that's fair.
And we can see particular, I think, confirmation of that in the NPPF paragraph 98, which you looked at in evidence in chief. You don't need to repeat it, but you can see that it's about access to open space, isn't it? Remember that?
Yes.
Okay. If you look at CDE1, which was the open spaces study, and you can turn within it now to page 37.
$27, sorry.
There's a difference here between the electronic version and the paper version. I'm looking for page 3737. Sorry if I read out the wrong number. An internal pagination 31.
Okay. 31 internal pagination.
Correct.
Okay. Okay, I'm there. Starts with the part 5 natural and semi-natural green space.
Yeah.
Yeah.
And in terms of what's sort of in and out, what's been included and what's been excluded, sites with no public access are not included within the audit and the study. This is natural and semi-natural green space.
That's for that category, yes.
For that category, public access is the determining factor as to whether the council counts it within its open space. Isn't that right?
Are you able to draw my attention to where it says that?
Current provision 5.2, and then you've got what's in the 23 sites, what's out, the ones which don't have public access.
What's out?
So current provision, sites which are included, sites which are excluded, sites which are included, public access, sites which are excluded don't. Isn't that right?
Oh yeah, so it says sites with no public access are not included within the audit of the study.
Yeah.
Yes.
So in other words, when the council is looking at the sufficiency of public open space in its area, natural and semi-natural green space, it excludes sites which have no public access. That is how important public access is to the analysis.
That's in relation to this specific typology
Correct.
of natural and semi-natural green space,
Correct.
which is a different typology.
To allotments,
To
of course
allotments.
it is.
Yes.
I'm not asking about that, because
Okay.
allotments, if you like, are a breed in their own right.
Yeah.
They are statutory or non-statutory allotments. We'll look at that in a moment. But for here, the critical factor in terms of whether you count it or not is public access.
On that particular,
Yeah.
that one.
When you then go back to 8, so part 8 of the document.
Although, yeah, I just would point out as well that it does go on to say their contribution in terms of biodiversity and wildlife is recognised.
I don't doubt it.
Yeah,
I don't doubt it.
Just to note. Yeah.
But they're not. In other words, if you say, is this an area which is deficient in open space as far as this category of green space is concerned, you wouldn't even count a site which doesn't have public access. That's the point. Yeah. Then you turn to allotments, which are a specific typology. Now, what it does is distinguishes between those in use and those which are not, but it says nothing about their status, does it? But that's not the most recent document in terms of what's counted and what's not. That's our allotment strategy. So back we go to CDE3, please. And when you have that, page 10.
Yeah.
Yeah, page 10 to 11, actually. What we see is that the Park Roads allotments are not included.
Yes. They're not included.
They're not included. And I think my understanding, but you can tell me if I've got the wrong end of the stick, my understanding is that that's because they're non-statutory.
My understanding is that this relates to it's not because of them being non-statutory, but more because these are the London Borough of Hounslow managed sites.
Where does it say that?
I'm not sure exactly where, but I'm also not aware of where it refers to them being on the basis of them being statutory.
So when the council is settling, it's okay. I take the point. Doesn't say either way. But what we can agree is that there must have been a specific reason why the Park Road site was not counted for the purposes of making an assessment of demand and supply for your borough in order to settle its strategy. That's correct, isn't it?
Yeah, it must have been. Yeah.
And so it follows. So the Park Roads allotments has not been included. So it follows that the only change to provision per household in this part of the borough, if planning permission is granted, is to add 38 allotments to the demand and supply position. Not lose any, because of course none are counted in this study.
Yeah, for the purposes of this study, yes, I suppose that would have to be concluded. Yeah. But it might be that, I mean, it might be that because this site isn't included within this study, a future study would also not include that site because it would remain in private ownership.
Well, it depends on the underlying reasons, but what we would know is that there's 38 new allotments in this area, wouldn't we?
There wouldn't be 38 new allotments,
which had not been counted in this study.
No, there would be no change in the number of allotments because there's 37 to 38 on the site at the moment, and even though they're not counted here, that position would remain if the 38 were re-provided.
I'll put the point to you, it depends on the underlying reason. But the demand supply position as far as this report is concerned, we know would be affected only positively by the addition of securing 50 years worth of 38 allotments.
I don't necessarily agree with that.
I see. So you think that this the council strategy would simply omit new allotment sites from consideration, would it?
I think it would omit. I think, well, if my assumption that this list has been drafted on the basis that they're council-owned, council-managed sites,
Yeah.
then that would be my. I would
And
think that
I had-
it would continue to not be included in that list.
Forgive me for talking over you. I didn't
Sorry,
mean
no,
to. My understanding is that the council strategy is to try to secure self-managed allotments, isn't it?
Self-managed allotments.
Self-managed allotments. In other words, that the council doesn't have to employ a contractor to manage them.
Yes, I think
Yes.
so,
Yeah.
yeah.
So that's part of its strategy, isn't it?
I believe it to be the case. Yeah.
Now, I want us to turn to the officer report now, please, and to look at how this matter was addressed in that. So you need to turn into C1. When you have it, please, to 7.28. 7.28. Thank you.
I'm there.
Now, again, a sort of fork in the road. I mean, there is an acceptance in the report, this report, that it's not fully publicly accessible if it's open to a category of the public. So it's not open to the public at large. It's open to, and you're relying, of course, on the ACV judgment to say, well, that's not unimportant, but it's nonetheless a section of the public rather than the public at large. That's right, isn't it?
Yes.
Yes, and that's the basis upon which the report was settled. What the inspector decides very much depends on the conclusions reached about the fallback position. Because, of course, on our analysis, the fallback position has no public access at all, not even any section of the population, correct? And that would have, again, it would follow, wouldn't it? I mean, I appreciate you don't agree with it, but it would follow that that would have to be taken account of in terms of the value of any loss.
Yes.
Yeah. And on our case, and supposing our case is right, matter for the inspector, I acknowledge, and I'm not seeking to cut across that decision making, but wanting to explore the hypothesis, bearing in mind that we say it's the real outcome here on that those two alternate outcomes. If only the visual qualities then are affected by the development in terms of the open space rather than the public access aspect, do you accept the reasoning in the previous inspector's decision on the value of the site in that regard?
The previous inspector, yeah, he does point out the value of the site regardless of public access.
I think I better take you to it. If you go to F1, please, and when you have it, paragraph 59.
49.
59.
59, sorry.
Thank you. That's okay.
Okay. Yes, I'm there, sorry.
Do you want to take a minute to remind yourself of its content?
Yeah,
Thank you.
thanks.
So the first thing is to, and actually, in truth, this penny didn't drop with me until I came to the site. There are two different cemeteries. One needs to be mindful of. One is the All Saints Cemetery, the cemetery which is immediately around the church, which is very small.
Mm-hmm.
And if you like, the far side of the appeal side, and then the other is the much larger cemetery along Park Road itself. Yeah, and when the inspector here is talking about Isleworth Cemetery, he's talking about that much larger site. So as you come from Twickenham Road, on the right-hand side, you've got a large cemetery. Yes, and so when he's talking about a key open space separating old Isleworth from the 20th century suburban development to the north, he says, no, I disagree, because you've got 20th century suburban development in Snowyfield Away, people newly housed in 20th century development in Snowyfield Away.
Yeah.
They've got the housing.
Housing's there.
As an aside. But and views over from and over the side from the south are dominated by the hospital buildings, which is right, isn't it? Because as you come up the Park Road, you've got the cemetery to the right-hand side, quite a large area of open space, and then you've got the development of the hospital, which is set in behind Park Road, and then you've got Snowyfield Away.
Yes, that's sort of, yeah.
Yes, in visual terms,
visual,
at least. Yes, okay. And so it's Isleworth Cemetery that performs the gap function, essentially. And so what I was putting to you is, did you accept the reasoning of the inspector? Not did you note that it exists, but did you actually accept it? Or are you saying you disagree with the previous inspector?
Well, I mean, I think it is worth pointing out that the site itself, as we've seen from the aerial imagery, has changed in the years since then, even though it's a small amount, but it has become more overgrown, and perhaps I think you could consider that it does perform more of a visual buffer than perhaps it did back at the time of the previous decision.
Okay, well, I'll ask Ms. Roberts to comment on that, because she too was there at the time, and there's a judgment there. I acknowledge, but that's something that any subsequent decision maker would have to grapple with. That in thinking about the visual qualities of the site and the importance to place on that as open space, that you've got a previous decision which doesn't regard it as a key open space.
Yeah, that's a factor that's going to have to be taken into account.
And then the next layer of analysis is then to give thought to the extent to which the development would actually impinge on that in any event, bearing in mind that it's been designed deliberately so as to maintain that sense of openness. Now, whether one thinks that's achieved or not is a question of judgment, right?
Yes, it's a question of judgment, yeah.
Yes, okay. And can I ask you just to confirm for me that this is an area where there's no formally identified open space deficiency? That's right, isn't it?
There's no formally identified open space deficiency.
That's it, and in part that is because of Sign Park. Is that right?
Yeah, Sign Park. I think Sign Park technically does not count as open space in the same way.
Are you sure?
Well, it's metropolitan open land.
That's correct. So is it, you sure it's
which
not
isn't the same designation as local open space?
No, it's different matter.
Okay, it's in terms of open space,
Yes.
it performs as open space.
Yes. Yes. Okay. Well, I'm going to have that checked, and we can help, I hope, with the. Just don't want to go wrong inadvertently on that. But what we can agree, I think, is that Sign Park, the inspector would have seen the extent to which it's publicly accessible.
Yes.
And that's valued. Obviously, that's a valued resource locally, and that's beneficial to the people and public of Hounslow.
Yes, a portion of the site is accessible.
Yes, and Sign House too is open to the public, and that's valuable not only locally but nationally, isn't it?
Yes, it is. It's albeit it does come with a cost.
Now, in terms of, I mean, you'll appreciate that our case is that the development of the appeal site is acceptable, and compliant with the plan, the development plan as a whole. Once the Section 106 points are sorted out, you can then say it's compliant with the plan as a whole, and we will. But without prejudice to that position, we've proffered 2 alternative granting style conditions, haven't we? And there's power, of course, to grant planning permission unconditionally or subject to such conditions as the decision maker thinks fit. Yes?
Sure.
And one should consider whether conditions are capable of overcoming a particular planning objection.
Of course.
Yeah. Now, we can see from the minute, we can turn to it if you like, but that it wasn't considered that the loss of the open space land was justified.
It wasn't considered that the loss was justified by the conditions.
No, well, let's go
Sorry.
to the minute. Let me not try and take it too shortly.
No, it's just be helpful.
So the minute is in C2. Have you got that? Go to 3 Park Road allotments when you've got it.
Yeah, so see, I'll just find it on there. Oh yeah, okay, so we have the committee minutes. Yes, sorry. On there.
So and the delegation arrangement in this local authority is no different as I've read it to any other, which is that you have a report from the head of the departmental section, such as planning and building, and that goes to the committee on behalf of the department. Yes.
With an officer recommendation, yeah.
But the officer recommendation is not just one officer. I mean, it's coming formally from the head of the department, isn't it?
Yes, it is, yeah.
It is. And in fact, here, not the head of the department, but head of development management, which is a subsection, presented the report to committee.
Yes,
see
it's
that
presented
from the minute. Yeah?
from a department, yeah.
Yeah. And what we know about the reasons was that members felt that the loss of open space had not been justified by the developer and were concerned about the loss of allotments when demand had increased.
Sorry, could you read that?
I'm reading from this.
Yes,
If you look at it, yeah, members felt. Do you see?
Oh yeah, okay. Yeah, so it is considered that.
I just read out what it says. That's all.
Okay.
So the question is, there's no evidence, is there, that there was any thought was given to the possibility of using conditions to overcome a concern?
Well, the decision was reached at the committee that with conditions it wouldn't overcome the harm that was identified.
No thought was given to conditions to overcome the harm, because of course the recommendation was for approval subject to conditions.
I think if there had been conditions that could have overcome the harm, those would have been discussed at the committee and agreed on.
No, well, there's no evidence of that. It just seems that they weren't considered.
The condition.
If there had been some thought given to it, it would be reflected in the minute, and it's not.
Right.
Fair point.
It's not reflected in the
It's
minute.
not reflected in the minute. Okay. But we know, you and I know, that a granting style condition can be imposed in certain circumstances, and you would do that. You can do that lawfully. Again, if this isn't for you, fine, pass it on. But you can do. You probably will know that you can do it lawfully, unless there's no prospect at all of the action in question being performed within the time limit imposed by the condition.
Yes.
Yes, and so what the effect of a granting condition is essentially to put the risk onto a developer. If something doesn't happen, if you're like no harm, no foul, the development doesn't take place. Yes? Yeah. Okay, so in terms of, we're going to only have a very limited discussion about this because the condition session is the right place for detailed discussion about conditions, but as far as the allotment's concerned, I mean, the without prejudice sort of counterfactual position, if the inspector thought that it was necessary to impose such a condition, we don't think it is, but if the inspector decided against us and said it is, there is an issue in that the council is the sort of holder of information about the availability of land, which is capable of being brought forward as allotments. I mean, we can ask for it, but in a sense, it's a matter for you whether you provide it or not. We've seen reference to 27 acres of council land being intended to be delivered as allotment land, but I mean, that's within the council's knowledge, not ours, isn't it?
Well, I mean, the council's taking steps through this project to identify land that might be suitable.
Yeah.
It doesn't mean that all of it will be suitable. It also doesn't, this is in a very early stage, and not all of it would be suitable for allotments. There's also, there's a lot that would go into that process that creates a lot of uncertainty about those sites. So there's no, yeah, I mean.
Okay, but I mean, one's still got to decide on what's the right approach here. I mean, does one assume that the strategy that the council's settled with a specific statutory duty in mind in order to fulfill it, does one assume that that is doomed to failure? Hardly.
I'm really sorry to interrupt, and I do so without meaning any discourtesy at all. But you would have heard earlier the course that was proposed in terms of how we deal with let's call it the 27 acres point. And my learned friend has made the point that part of this discussion is going to be reserved over until that session, was the point made to Mr. Hall a moment ago. What I'm slightly concerned about is that even the questions that are now being asked are ones which plainly feed into that issue, or the issue feeds into it, and Mr. Hall referred to it naturally enough in an answer a moment ago. And I'm a little bit twitchy, to put it bluntly, because of course I have to re-examine in due course, and the natural way in which I would re-examine on this topic is to invite Mr. Hall to answer various questions in relation to the answers he's given, where he's referred to what the council believed to be the available supply of land, and he's already said in an answer he's referred specifically to the land identified in the Growing for the Future initiative. So whilst on the one hand, I never like to interrupt anybody's flow, and I don't want to do that. On the other hand, I do want us to tread very carefully, because what I don't want to happen is that I find myself in due course feeling that the proper course is to re-examine on this issue, and then my learned friend gets raises the point that this ought to be dealt with tomorrow. So we are treading quite a fine line, I think, at the moment.
I think that's a fair comment. I'm quite happy to move on. Yeah. Okay, but not off conditions altogether, just off the allotment, the sticky subject of the particular allotment provision. So we just move on from that. Let me just put it in this way: the two alternate. I mean, we really here are exploring the sort of nook and cranny of a case which is not, if you like, our own, because it's without prejudice to our primary contentions, of course. But we do have to do that reasonably. So, as far as open space is concerned, we've talked about the sufficiency in the sub area, the development requirements. In other words, arising from the development itself, the housing to open space requirements, they're met by the development proposal. And so compensatory provision, if any is needed, can be across the borough, can't it? If such is needed.
Well, that's where I think the council disagree in terms of how a condition might be worded, in that we don't think that it's appropriate for the reprovision, if one were to be put into a condition, to be secured at the borough-wide level. We think it to be secured at the Isleworth and Brentford level, where the allotment would be lost, or the local open space would be lost. So,
but just pausing for a moment, that's contrary to normal practice, because where you've got a sufficiency of open space and the development meets its own requirements, why would you need to be making compensatory provision within any particular sub-area?
We're getting into the same point. I'm going to have to re-examine it on this point, and we're going into the subject of conditions.
No, forgive me. This is a quite separate matter. It had nothing to do with the particular allotment provision. This is about the alternate condition on open space, and it's about the right parameters for the discussion. So no, that's not a fair interruption. And actually, I'd quite like an answer.
Can we just deal with this one question? Would you like?
It would be helpful to just briefly repeat that. Yeah, thank you.
Disagree if you want to, but we'll have to hear your reasons, because you've got a sufficiency of open space. Not talking about allotments, but open space in the sub-area. The development's own requirements, if you like, the development consumes its own smoke in terms of open space requirements. Compensatory provision can therefore be borough-wide, can't it? You can have a contribution, for example.
I have no comment on that.
Well, it's obviously, that's because what I put to you is obviously right, isn't it?
That's not the case.
Well, but why? What's the reason?
The provision that's being lost in the area should, in an area where there is, not much reasonable prospect of increasing the open space provision, there shouldn't be a loss of open space just because there's currently a sufficient supply.
Thank you. Okay, well, we'll do that in submissions. Turning then to design, and back into the report, please, to committee. If you have that at CDC1, and in it, 7.65, please.
Yes.
Thank you. Do you have a subheading above that paragraph, design and appearance?
I do, yes.
And we can, just to sort of orientate ourselves, we've got a section which runs from 765 all the way down to 7.83.
Mm-hmm.
Yeah. Now, Ms. Roberts' evidence refers to high quality design, in particular the delivery of high quality homes. I think she's made mention of the quality of the homes and the associated landscaping 3 or 4 times in her evidence. So it's a matter that she gives some emphasis to, isn't it?
Mm.
Is that right?
She does give emphasis.
Yes. And you accept, I think in evidence in chief, to be fair to you, that the development reflects good design in that it reflects all relevant design policies and codes and guidance, and it's no part of your case, is it, to suggest that it does not?
It does reflect good design.
It does reflect good design,
mm-hmm.
because it's compliant with all relevant design policies, codes and guidance.
That's correct.
That's correct. So if you go to the framework,
yeah,
which is at D1, or wherever you have it. What paragraph 134?
Yes.
This is This new paragraph corresponds with the government placing additional emphasis on design, isn't it?
Mm-hmm.
Yes. And it is about creating an incentive for developers to up their game as regards design.
Yeah.
Yeah. Development that's not well designed should be refused. So that's pretty stark.
Yeah.
Conversely, do you see?
Yes.
Significant weight should be given to development which reflects local design policies and government guidance on design, taking into account any local design guidance and supplementary planning documents such as design guides and codes, etc. I've slightly mangled that as I've read it out, I'm afraid. But the point being, you agree that the reason the development reflects good design, it reflects all relevant design policies, codes and guidance. It's no party's case to suggest that it's not. It should attract significant positive weight in the decision now, shouldn't it?
So what paragraph were we in again? I was distracted.
134.
134.
Framework, page 40 in
It's this is a sort of new bit of text in the 2021 framework. It gives, doesn't it, in circumstances which apply here, where a scheme reflects all relevant design policies, codes and guidance, it should attract significant positive weight in the planning decision, shouldn't it?
It does say that.
It does say that. Now, in the planning report, the officer report, that paragraph 134 was referred to, wasn't it? You can check it if you like. That was at 7.68. Yes? So evidently, the officer had that in mind to attribute significant positive weight to design when reaching the conclusion at 8.4. That's fair comment, isn't it?
That's his paragraph at 7.68.
So 7.68 cites the policy,
Yeah.
8.4 draws the planning balance. You can reasonably understand, having given considerable thought to design, that that policy would have been applied.
Yes, that policy would have been applied.
Yeah. Okay. And not only is that policy of really placing significant importance on design at the heart of government policy, it's also to be seen in the London plan too, isn't it?
Yes, the importance of good design is backed up at London level.
Well, there's a renewed interest at regional level in design, and the policies of the London plan reflect that, don't they?
Mm-hmm.
Yeah. Is that, I mean, all of that seemed to come as sort of news to you. I don't mean to be discourteous, but it's not, to be fair, it's not reflected in your proof, that is it?
No, it's not reflected in the proof.
Okay. And actually, it's no mean feat in a conservation area to achieve, even on your case, a neutral effect. Because you've got a conservation area with a range of listed buildings around it. So part and parcel of what constitutes good design is respect for the historic environment, isn't it?
Mm-hmm.
Yeah. So if you achieve that, if you achieve preservation, actually it tells you something about your design, doesn't it?
I think well,
it must do.
I think it would, I still maintain that it has a neutral impact.
But in order to achieve neutral impact in a conservation area with listed buildings and the like, you've got to design your scheme properly, don't you?
Yeah, so the scheme is, it has a good design,
It does.
but that's only in such a way that it's been designed to fit within the context as best as possible. So it doesn't mean that it's, an outstanding form of design. It's a design that's been developed in as sensitive manner as possible to align with that very high quality sensitive setting.
I see. So the reason we don't see the same sort of thinking in the officer report reflected in yours is because it would only be if it was outstanding design that you'd be giving significant positive weight to it. Is that right?
That's the case that we took. We'd only give significant weight to an outstanding design.
I see. But you'll accept now from me, looking at 134, that's contrary to national policy.
Yes.
Yes. You've set the bar too high, haven't you? You should have given significant positive weight to that, shouldn't you? Yes.
Perhaps. Yes.
Yes. And Ms. Roberts evidently has given her emphasis on high quality design in terms of architecture and landscaping, hasn't she?
She has.
She has. So as far as we started to look at the heritage assets in that design context, and we just have, I've got some short points that I want to put to you on that, which we've got time for, I think, before lunch. So as far as the heritage assets themselves are concerned, there's a statement of common ground on significance as between ourselves and yourselves, between us, the appellant and the council, isn't there?
Statement
Yeah.
common ground, yes.
And what that doesn't touch on is Scion House itself. But should I assume that if the council had disagreed with what was said in Mr. Bridgeland's proof about the about Scion House, that the council would have said? Should I assume that?
I'm not sure you should assume that, no.
Okay, because the position, of course, that's left is that as far as that list of buildings is concerned, the only evidence before the inquiry is that of the appellant. So, having said nothing, it'll be that's all that the inspector can take reference from. And you'll have heard in the Heritage Roundtable session, the only person who said anything about the significance of Scion House was Mr. Bridgeland. Your conservation officer was here. He didn't say anything.
Yeah, well, we've not purported any harm to the heritage asset arising from the development itself.
Yeah. But in the position that the inspector, if you put yourself in the inspector's position, the only evidence on this matter is Mr. Bridgeland's. I mean, you'd accept, would you, that unless somebody contradicts it, that's to be accepted?
Well, a heritage matter was never a point of dispute from the council's point of view in terms of the impact on heritage assets.
Right.
In terms of it wasn't a refusal reason, so it's not a reason that we've been pursuing.
No, and you're not saying here and now that there's some aspect of what Mr. Bridgeland said about Scion House that you disagree with, or that anybody does.
Well, some people might disagree with it, but the council, we haven't taken a stance against. We haven't said that the development is harmful in terms of impact on heritage assets.
You're the council's only witness.
Yes.
If and to the extent that there was going to be any disagreement, you would have given that evidence, and you haven't.
Yes.
Yes. You're not alleging any harm to any heritage asset, as we know. Can you just help me with this factual point? The council's conservation team the conservation officer was involved in scheme development, including in relation to massing.
Yes.
Yes. So it's not just a question of having provided a consultation response at the end. There was engagement. Through design development, wasn't there?
I believe so. Yes.
Yeah.
I wasn't involved in the process myself, but
no. Okay. And the officer report. The report to members, that was based on conservation officer advice, wasn't it? So the text that we see in the officer report, that came from the conservation officer. It may have been edited, but it was primarily from him.
Yes, I think the officer report reflects the view of the conservation officer.
Yeah, and the council has had all of the inquiry material, including the evidence from the Iowa Society. And it hasn't changed its position, has it?
The council hasn't changed its position on the impact on heritage assets arising from the proposed development.
And actually, The dispute between ourselves and yourselves, to the extent that there is any on heritage matters, is that your most recent response to the inspector insists that the Conservation Office area is preserved, whereas our evidence is that there's enhancement. And so that's, if you like, that's where the battle lines are drawn as between your counsel and the appellant, not whether there's preservation or not. That's right, isn't it?
Yeah, we've said that the impact would be neutral on the conservation area.
And we've said,
And you said it would be an enhancement.
So that's where the battle line is.
That's
between preservation
the
and
difference. Yes.
That's the difference. Yes. So if you could turn for me to the London plan. So that's within the D series, I think, of the documents.
Hmm.
And when you have it to HC1, which is, I think, 294 of the plan.
Yeah.
And just take a beat. Just remind yourself of it's kind of, because it's quite a rigorous, locally specific policy.
Mm-hmm.
C in particular.
Yeah.
Yeah. It's your view, isn't it, that the development complies with this policy?
Yes, we haven't purported harm to the heritage asset, Sign House.
I don't put that in the negative, though. I mean, I've put to you that it complies with that policy. The scheme as a whole complies with the policy, doesn't it?
Yeah, we've found no breach of that policy, so it is complied with. Yes.
Yeah. In a similar vein, if you go to D, the local plan. And within it to page 143.
Mm-hmm.
It obviously, because it's going to be compliant with national policy and the statutory regard seeks preservation at a minimum. And of course, the proposal, as we agreed, complies with that. You look at 6.12.
Yeah.
The assets within the local authorities area define its origins and illustrate its distinctiveness. So the heritage assets are really important for the borough, aren't they?
Heritage assets are greatly important for the borough, yes.
They are. And in particular, I don't mean this in a sort of, in any sense, negative way, but the borough's boasting of the Grade 1 statutory listed buildings, such as Sign House and the other listed buildings. It's boasting of it because these are among the jewels in the crown of Hounslow.
Yeah, they're extremely high quality buildings.
Yes, and it's and the council and presumably the residents too. You know, these are things which are valued.
Yeah, they're valued.
Yeah, they're valued there because they're important. Mm-hmm. So the Sign, the Isleworth conservation area, they're of particular importance, and they're driving the policy approach. And so when you have compliance with CC4, which must be your case. Yes?
Yes.
Look at CC4, it's about achieving preservation. Isn't it?
It's about preservation.
Yes. Go up to, it's 142.
Mm-hmm.
Yes. That's no small matter. That's important, isn't it? Development within a conservation area and within proximity of some of the most important listed buildings in your area, and it achieves policy compliance. So that's not just a neutral thing. Actually, that's a matter of some significance, isn't it?
Yes, I suppose it has, some significance.
because you're going to have policies within a local plan which have greater or lesser importance for the borough. And so compliance with them is of greater or lesser importance when thinking about compliance with the plan as a whole. Do you follow me? Yes.
Yes.
Do we see anything in your evidence directly about the implications of compliance with, for example, HC1 and CC4?
There's nothing about compliance with those or not.
Okay. I'm just about to embark upon a linked but discrete topic, and I noticed the time.
How long do you think you would be?
More than I've been already. Let me have a look. I think I'm about 2/3 of the way through.
In that case, I think, yeah, it's time for a lunch break.
Yeah. Okay.
Yeah, so as I said yesterday, normal guidance is an hour for lunch.
Yeah.
So I'm sorry, Mr. Hall, you'll be incommunicado again over lunch. So the inquiry is adjourned till 2:00, when we'll continue with cross-examination. We continue. Okay.
There's one from me. There's the one from you as well. Shall I go first? Just one matter of housekeeping, which is in relation to the way in which witnesses are heard tomorrow in the roundtable sessions. So far as solicitors are concerned, I think the intention at the moment, bearing in mind your helpful indication earlier, is that neither of the main parties are proposing to have their solicitor here. I think they'll both be available on the end of a telephone if anything unexpectedly arises that will enable us to contact them. Insofar as the attendance of either of those witnesses or the ecologist by teams, if that was a route being considered, then I have to say at the moment I am pessimistic from the inquiries I've made that is going to be easy to accommodate tomorrow, if that is what is proposed. You will have gathered the other day that it proved difficult to synthesize the live stream and the Teams facility, and the person who was able to do it, the last I was told, is not available to do it tomorrow. What you will have noticed, sir, is that at the corner table there's a constant turnover of personnel to help at least get the live stream running. So I wonder if thought could be given to whether or not or how those witnesses are going to be giving their evidence tomorrow and what the various alternatives are. I don't think there's a problem so far as our solicitors are concerned, because if a problem arose, we can contact them and then convey their responses. It's more the ecologist. I don't know what the position is with the ecologist.
Okay, I'll give that some thought.
Thank you.
Yes, so just a brief question about timetabling today. There was one more interested party who wanted to speak today. It's Mrs. Aloysius, and I understand she had exchange with the case officer. I just wanted to check, because I know we're kind of running a little bit tight in timetabling. I think it was envisaged she would speak at the end of the day once the evidence had been heard today. And I just wanted just a bit more, just check how we are on timetabling with that.
Well, is it on an allotment matter? It's not on speaking on a heritage matter or anything else, is it?
That's my understanding, sir.
Yeah, because I was going to say we've done and dusted that issue and sort of moved on. So, I mean, if somebody wants to present evidence on the allotment open space issue, then okay. But I don't want to disrupt the flow of the cross-examination process.
Yes, I think the intention was it would be after all of that had concluded at the end of the day. It might be that this can be solved with the statement being sent. I think that is being sent to Mr. Brown.
Yeah, that's another alternative. Yes, that'd be another alternative. So maybe we'll see where we are. But I mean, if it's an allotment issue, then okay, if we can accommodate it. But if it's a heritage or other aspect, then I think we've moved on in terms of the process.
Yes.
Okay.
Thank you, sir.
On the ecologist, I think our intention was that they'd only be available virtually, so we haven't actually organised for someone to come.
No, I appreciate that. That's what we sort of intimated yesterday.
Sorry, that's the point, is it? Right. Sorry. No, I mean, I suppose I'd assumed that because we'd been able to manage it from...
Well, yes.
Yeah.
Me too. I'd wrongly assumed that as well. Yeah, I mean, one alternative, and this is just off the top of my head speaking, would be we've obviously got a virtual closing session lined up for September, where there's going to be a Teams facility. And I off the top of my head, my knee-jerk reaction was whether possibly to add it in to that day. That's just a very quick initial reactionary thought.
That's one possibility. I think I don't want to argue with you, but I'd be usually a bit hesitant about that because it would come immediately before closing, so I would struggle to
I
close
take your
on it.
point. Yeah.
So not wanting to sort of put a fly in the ointment, but another alternative might be that if there are questions which they can help with, can they do it in writing as the other
Yeah,
question?
that's a possibility, in which case we'd have to talk about the sort of timescales and that process.
Yeah, so we could do that by way of sort of directions from you.
Yeah, okay,
Yeah.
that might be another option.
I suppose the helpful thing about not delay, but the programming, setting the closing for September, is that actually if you wanted to provide for a sequence of questions and answers and say responses, because not forgetting that
the society,
it may not be uncontroversial.
Yeah,
exactly.
the society may also have questions.
Yes, exactly. Yeah. Yes, exactly. So that's. I wonder whether we should just take this offline now, having identified a sort of procedural problem. Let's try and come up with a solution.
Does the society want to comment, because you've made?
Yes, well, if it would assist to give an indication, we do have some questions. I don't have a list obviously to hand now, but it is the case that we will have questions for the ecologists. So whether that's done in writing, I think our preference would be that that's done in a session or already. But if writing is the only way to facilitate that, then we'll do that. But we do certainly have questions.
Okay, well, maybe we'll revisit this.
Should we try and work it out offline?
Yes.
Put some thought to it.
Yeah.
And bring it back to you and see if we can get something you're happy with.
Okay. Right. Okay. Thank you. So with that aside, we're ready to start in earnest then. Okay. Thank you.
Right. Good afternoon to you.
Good afternoon.
We'll start back in to your proof of evidence at paragraph 2.2. Back up. Yeah. Okay. No problem. So all that you're doing in this paragraph, as you know, is setting the decision-making framework.
Yes.
And there's two questions. There are two questions. The first is, does the development accord with the development plan? And then the second question is, if not, whether material considerations nonetheless indicate that the permission should be granted. So those are two separate questions, aren't they?
They are.
Yeah. And the first question is resolved not by identifying whether there's some policy conflict, because of course you can have policy conflict and still accord with the plan as a whole, can't you?
You can do, but our position is that it does not accord with the development plan as a whole.
I know what your position is. At the moment, I'm on approach, as will have been,
all right, or
should have been, I hope, clear.
Yes.
So you can have policy conflict and still accord with the plan as a whole. We know that.
Mm-hmm.
In fact, there's case law on it.
Yes.
Yes. The planning department's report to the members said that the proposal was broadly compliant with the statutory development plan. Would you like me to take you to that part of the report?
You can do, just for clarity for everyone.
Of course. So CDC1.
Yes.
Paragraph 8.1.
Yes, I can see that.
Yeah. So I'm right, aren't I, that the planning department's position was that the scheme was broadly compliant with the statutory development plan?
The officer recommendation in that report was that it was. The council's ultimate decision was that it was not.
Again, focusing on the question I'm asking, otherwise one
Yeah.
third of cross-examination remaining will quickly become half.
All right.
Okay. So that was a conclusion about accordance with the development plan as a whole, wasn't it?
Yes.
Yes. And that was, in fact, without having considered the fallback position in line with our case, isn't it? It was assuming some ongoing allotment use, wasn't it?
Yes.
Yes. Now, obviously we've agreed, because it's long settled, that you don't have to accord with each and every policy. So there's then a question, isn't there, of judgment. about what is the implication of conflict with any one or other policy. Yes?
Yes.
Yeah. And putting GB2 and G4 aside, and also GB8, which we've talked about, putting those to one side for the moment, and thinking about compliance for now, if you look at section 7 of your proof of evidence,
yes,
when you're explaining what policies are relevant, you refer at 7.4 to the statement of case and the agreed statement of common ground.
yes.
So you have, if you like, by reference considered, I suppose, the other policies, but we don't find anything else about compliance in your proof, do we? Your proof is focused on conflict with policies, not about compliance with policies.
That's correct, yes.
Yes, yeah. And in terms of compliance with the development plan as a whole, if you look at your 15.3,
yes,
all I have is an asserted position, which is I consider that the proposal is not in accordance with the development plan overall. But I don't have reasoning. So in other words, if I want to find out why you think that, it's not certainly not written in the proof, is it?
Well, hang on a minute. I mean, non-compliance with any one policy can, if it doesn't comply with any policy, then it can be taken to be non-compliant with the development plan as a whole.
What I put to you is factually correct, though, is it? That although I find an asserted position in 15.3, I don't find any reasoning in the proof itself as to why there's compliance with the plan as a whole. Okay,
yeah, no, there's no.
And that is right, isn't it? Whether I hang on or not. So let's look at the statement of common ground then. CDA6, please.
Yes.
And within it, section 6, and if you turn for me to 6.4.
Yes.
We see a very long list of local plan policies which are relevant to the appeal, some of which will be more important than others, won't they?
Sure.
Yes. And so, for example, policies like heritage and design will be of particular importance. Yes?
They're of importance in the round, yes, but in terms of the specific refusal reasons that we've defended this appeal on, there's obviously, they take less importance because we haven't focused on design as a harmful feature.
What I'm asking about at the moment is that not all policies in the development plan are equal. Some are dealing with matters of really fine detail, and some are dealing with matters which are of real importance and priority.
Yes,
they're not all equal, are they? So the location of waste bins might well be a matter of policy, but it's not going to be as important as whether a policy respects Grade 1 listed building or not.
Yes, in the case of this scheme, yes.
Yes. So we've got a very long list of policies at 6.4, some of which will be more important than others, one assumes, and you agree, right? And then we've got a similarly long list of policies in the London plan.
Yes.
Yeah. And other than GB2 and G4, and you say GB8, there's compliance with the statutory development plan.
Yes.
Yes. It has been said that given the numerous conflicting interests that a development plan seeks to reconcile, it would be difficult to find any project of any significance that would be wholly in accord with every relevant policy in a development plan. So it's not unusual to find single instances of policy conflict, is it?
No, it's not unusual to find some instances of policy conflict. However, it's the degree of the amount of that policy conflict that I think is important.
I agree. But we can come to a happy agreement, I think you and I, that it's open to this inspector, open to our inspector as a matter of judgment in this case, to conclude that notwithstanding the conflict you identify, that there's compliance with the plan as a whole.
That's a position that you can take. I mean, yeah.
He can reasonably do that. He can come to that as a matter of judgment, can't he, in this case?
He could come to that as a matter of judgment.
Reasonably.
It's a matter, it's a matter for him to,
That wouldn't be an unreasonable judgment to come to in this case, would it? And we know that because actually that was the conclusion reached by your head of department in the report to council members. So you can hardly say here that would be an unreasonable judgment to come to when you literally just seen that your head of department came to the same.
Yes, exactly. A judgment can be made.
Yes.
Planning is it's always a balancing act, isn't it? You come to on one side or the other, and policies can be interpreted.
Now, in your proof, paragraph 1.3,
yes,
suggests that you weren't involved in the application process.
That's correct.
Well, it's not. It's correct that that is what it says. It's not accurate in the sense that the report to members was a report on behalf of a department of which you are a member, and your delegation process is that the report's presented on behalf of the department as a whole. So to that extent, you were involved, weren't you?
I don't think that's a fair statement. I mean, yes, it's a recommendation that's put forward from a department, but it is an individual officer's recommendation.
No, it's not. It's the individual officer, case officer writes the report, but it is approved and presented by the head of department formally to members as the report from that department to the council. That's the way it works. Did you not appreciate that?
No, okay, that's correct.
It is correct.
Yes.
And so to that extent, I'm not saying that you were the case officer, you were involved personally in this, but to that extent, in that you were an employee of a department which made a recommendation, you were involved.
To that degree, yes.
Yes.
Sure.
And I just do have to check this with you because I didn't see anything in your evidence about it, but are you a member of the Royal Town Planning Institute?
I'm not.
Nor a chartered surveyor?
I'm not a chartered surveyor.
Okay. But your head of department presumably is?
The head of department, I'm not sure off the top of my head. Sorry about that.
All right. So I have, I hope fairly, put to you what we can tell from your evidence about the development plan as a whole, and what we're left to wondering about. And in terms of the clues to the reasoning, if we look at your page 66, and within it 14.24, under the heading disputed benefits.
Yes, I can see that.
Yeah. And so I'm seeking to test this, so it may be that you can put me right. But here, if you look at 14.24b, alterations to vehicular access, that's a policy requirement, so it's not a benefit, so it's treated as wholly neutral. Yeah.
Yes.
Would I be right in thinking that where you've, if you like, understood that to be policy compliance, for example, with HC1 or any of the design policies, you've essentially treated that as a neutral matter? Tick, no, not harm. Tick, it is neutral because it's policy compliant.
Mm-hmm.
Is that correct?
Well, it's necessary in order to make the development acceptable and compliant.
And that goes for policies, including design policies and things like policies like HC1 too.
Yes.
Thank you. Mr. Roberts' conclusion, by contrast, of course, is that there's a single policy conflict in relation to the loss of open space, but that the development complies otherwise in all other respects of the statutory development plan. You've seen that. It's a rebuttal, paragraph 5.1. So there's obviously two different evidential positions in front of the inspector, and we can ask her about that in due course. I said single, and that's because there aren't really, are there here, two separate policy conflicts. The issue is about the loss of designated open space. That's the policy conflict here, isn't it?
Yes, it's the loss of local open space.
And not wanting to go right back round the circle again, but it isn't a policy conflict, is it, not to retain what was once allotment use?
Well, allotments are a form of local open space.
Yeah.
And
So
that's why the GB8 is accepted as being a relevant policy in the refusal reason.
Well, because it's about use of land which is designated as open space. So yes, okay, thank you. So the issue is about the loss of open space primarily. And Ms. Roberts, as I've indicated earlier, pulled the punch in terms of written evidence, but the Section 106 having been agreed will now say that the development complies with the plan as a whole. That having been resolved, she put it in her rebuttal, of course she did, but that's now an agreed position in terms of the Section 106. So that's coming. We must now, though, move on to the benefits of the scheme, and firstly to cross-subsidy benefits. And I'm here talking about the funding of heritage works as secured in the Section 106 planning obligation.
Right.
Yeah. So cross-subsidy, firstly, under the heading benefits. Would you accept that a cross-subsidy is a way of conserving a heritage asset?
It's a way of conserving a heritage asset.
Yeah. And that not all cross-subsidy is enabling development.
Not all cross-subsidy is enabling development, yes.
Correct, yeah. We'll come back to that in a moment. In terms of I suppose wanting to start with your end point in evidence, in terms of what weighting you've actually given this cross-subsidy benefit. Could you turn to Ms. Roberts' rebuttal, Appendix 5, please?
Yes.
This is a summary table which is seeking to put in one place our position, council's position, on weight to attribute to benefits. And it starts with the restoration of Sion House. And where we have an understanding of the weight that you've attributed, we've included it in the table. Where we haven't, there's just text. And so you can see that the appellant's position in terms of the cross-subsidy benefit is significant weight.
Mm-hmm.
And your position is set out in terms of various arguments which you advance, which we'll come to, of course. But what weight do you say the inspector should attribute to the funding of the facade works and the works to the stateroom?
Limited weight.
Limited weight to the works to a grade 1 listed building.
Sorry, can you just give me a moment, please?
Yes.
Thank you. I think it should be substantially moderated weight. as per what was defined by the previous inspector.
So I'm sorry, I just want a nice clear answer. What weight are you, is it that you haven't yet formed a position? That's fair enough if you haven't, but if you actually got a position on the weight that you are advising the inspector who should attribute to this benefit?
I think it's between limited and or moderated weight, basically highly moderated weight.
But what does that mean? You've only given 3 categories in your
I'd say limited weight.
Limited weight.
Yes.
Right. That's your professional advice to the inspector.
Yes, that's my professional advice. Limited to moderate at best, I would say.
Right.
I'm sorry for not a clearer position on that, but it is a matter
it's not
for the
position that I'm going to take issue with.
Yes.
It's the advice.
Right.
So what was the, I can see that's the end point that you've got to, but what was the starting point?
The starting point was to, in what way? Sorry.
Well, you've described, I mean, I do understand the language that you've used, which was, you said significantly moderated weight. Now, what that implied to me was that you started from one position, which was a certain amount of weight. You moderated it by virtue of the various matters that you took into account, and you arrived at moderate weight or limited to moderate weight. Yes?
Yes.
Yes. So what was your starting point?
Well, yeah, I mean, obviously the starting point has to be that, it's a building of national importance, local importance. We recognise the importance of preserving, historic buildings. So the starting point has to be that it's significant weight, but then, that's pared down because of the reasons why, the reasons that have been presented in my proof.
Yes. So if you go to Ms. Roberts's rebuttal appendix 2,
Yes.
I suppose quite reassuringly, if you look at decision making in relation to heritage assets, you'll see exactly the process that the inspector has instigated set out here. Paragraph 2, the statutory regard, 3, approach, identification of significance implications, identifying, and then do you see over the page, identifying significance and then implications of harm or benefit.
Yes.
Do you see? Now at 9, paragraph 9, the reason why you've started with significant weight in respect of this grade 1 heritage asset, I would surmise, but you can confirm it or otherwise, is because the government policy is that benefits to significance attract, if like, equivalent weight to harm to significance. So in other words, the government's focus is solely really on significance. And then to the extent that a proposal harms significance, that must be given considerable importance and weight in the decision. And conversely, to the extent that a proposal benefits significance, better reveals significance, for example, that too should be given considerable importance and weight. Or in the framework's language, great weight should be given to the asset's conservation.
I think it's important to just, if I just can take myself.
Have you got that legal note in front of you?
Yes, I do.
Yeah.
I'm just taking myself to paragraph 199 of the framework. Now, it says that great weight should be given to an asset's conservation, but that's when considering the impact of a proposed development on the significance of a designated heritage asset. Now, my planning interpretation of that is that because the works here are a consequence of the development and not a part of the development, paragraph 199 would not come into force in this particular case.
Let's take this in stages. The glossary definition of conservation is the process of maintaining and managing change in a way that sustains and, where appropriate, enhances significance. Yes?
Yes.
Yes. That's just what it says.
That's what it
so
says.
We don't disagree about that.
Exactly.
Part of the development proposal here is a Section 106 planning obligation, which will only come into effect if the development is implemented. And it will then, the landowner will then be bound to carry out the works which are incorporated within the Section 106. Yes?
They would be bound to, yes.
So it's not that there's no causal relationship between the development and the heritage works. They are part and parcel of what's proposed, aren't they?
Again, I would say that they're a consequence of the development, because the Section 106 is a consequence of the development.
Yeah.
But it's not as if the development itself is affecting the heritage asset.
But here, a consequence of the development is that significance is positively affected. Why would you leave that out of account in the planning decision?
Clearly, the significance of, maintaining a heritage asset is accepted, but because of what I said, I don't think that paragraph is relevant.
Well, all right, I'll make submissions on it, but if we simply, that it can't be right, and the reason I think it's not right is because you yourself have accepted, when I asked you questions about this to start with, was that you had gone from a significant weight to attribute to this benefit to something else as a result of the moderation process. So you must have had some reason for attributing significant weight to that to start with.
When I said that, I think it's probably fair to say that starting at significant was based on my initial thinking that you go into something thinking that historic buildings need to be preserved, and it was not an educated position at that stage. So that's what, and then after after finding a bit more out about it, that sort of position was moderated.
Should we put it, perhaps this is overly academic as a discussion, and I can deal with it in submissions, but perhaps we can deal with it in this way. Unless the inspector is prepared to moderate the weight to attribute per the various arguments you include in your brief, we can agree, you and I, that the weight would be significant positive weight to attribute to that cross-subsidy benefit, and we'll now come to deal with those arguments. Is that fair?
I don't think significant weight necessarily would need to be given to that, because, as I said, it doesn't. In my view, it doesn't. Well, paragraph 199 does not come into effect here,
So
and that's where it requires great weight.
You don't think, as part of a development proposal, that making positive change to significance and conserving the heritage asset, you don't think that would be deserving of significant weight in the planning balance? Is that your position?
I think the significance is something for the inspector to decide.
No, I'm asking you.
I've made my position clear that I think that it could be given limited to moderate weight at best at this stage, following a review, and that's the position.
No, I've asked you. Obviously, that's your end point.
Yes.
I'm seeking to get agreement with you, if I can, about the right starting point. Pretty important. It should be significant weight as a start point, shouldn't it? It's obviously a very, very significant benefit of a development in relation to one of the most important listed buildings in the country.
I think it's a subject for the decision maker, and it.
Well, that's the second time you've avoided answering my question, but would you give me a direct answer instead?
I'd say, okay, moderate to significant weight.
As a start point.
As a start point.
And why would you be giving it moderate to significant weight? What's taking it down from significant weight?
Well, it has to be considered in its context.
Which is that it's one of the most important buildings in the country.
Okay, I think it's probably best if, I accept, okay, that, starting point should be significant weight, yes.
Yes.
Okay.
So the starting point,
Yes.
having considered the matter properly and carefully, the starting point should be significant weight, shouldn't it? And then we come on to see whether the arguments should reduce weight from that. Isn't that right?
Yes, I think I
Yes.
can agree to that.
So looking at your section 14, and page 59 of your proof,
Yes.
paragraph 14.9. That concern about costings has now been overcome, I think, because of the detail in the section 106, which was then reproduced in evidence, but obviously post, which you would have only had post receipt of your proof.
Yes.
Yeah. So that, in a sense, that needn't worry us. We've now got a detailed costing breakdown.
Yes, we do have a costing breakdown now. Yes,
Yeah.
It was provided at a late stage.
Okay. And in terms of the relationship between the proposals in the section 106 for this scheme and those for the previous hotel planning permission and the marquee planning permission, I'm conscious that you've had a note which is updated and sought to tidy up the material before the inspector. Are you in a position to answer questions about that or not?
Well, we haven't had a good chance to look at the note yet, the latest note. We're
Yes.
talking about the Errand note,
The sort of errata.
errata note, sorry.
Yeah,
Yeah,
it's okay. Yeah, it's okay.
Right.
So is the answer no?
I've had a brief look over it, but I don't think that, we've considered it in enough depth to go into that in a lot of depth.
Right. Well, I'll ask one question, and if you can help, excellent. If you can't, no. Do you accept the legal analysis in terms of the scope and effect of the original the hotel section 106 and the marquee section 106 in terms of what they provide or not?
I'm aware of what they provide.
Yes.
The hotel one is quite clear because there's a full schedule of works that was secured by
Yes,
that.
that's it.
The marquee permission came with, I think there were 3, it was to do with refurbishment. There were sort of 3 elements to that, where the monies from that was supposed to go, and they were all sort of heritage related and
Yes.
heritage works at the estate.
The marquee planning permission actually is time limited, isn't it? It's a temporary
It
consent,
is, yes.
and it requires to be essentially renewed.
Yes.
That's not secured as yet, but it's actually, in the scheme of things, it's a relatively smaller amount of money. It's about £66,000 per annum, isn't it?
Mhm.
Yeah. Okay. I think we're going to leave it in this way, that if there's disagreement as to the sort of legal analysis or as in terms of the costing, that we will hear about it. Otherwise, we'll just proceed on the basis that it's not contentious. But I'm not going to ask you any more questions about it.
Okay. Right.
The previous planning application, which came to appeal, and the decision letter that we've seen, that gave rise to significant heritage harm, didn't it? It was less than substantial to an important heritage asset.
Yes.
Yes. And that was why it was necessary, wasn't it, for that inspector to consider alternatives. For example, alternative sources of funding.
That was the reason, yes.
That was the reason, wasn't it?
Yes, the reason why. Yeah, they were.
If you look at the decision letter, because I know my learner friend responding to that, take you to the decision letter.
Mm-hmm.
So sorry, CDF1, and then let's look at paragraphs 24 and 25. But questions, so just take a beat just to remind yourself of the content of them, and then I'll ask you a question about 25.
Yes, okay, I've read that.
Thank you. It's paragraph 25 I'm going to ask you about. On the contrary, have that. It says, on the contrary, the onus is on the I think, appellant to demonstrate that there's no way to fund the necessary repairs other than by implementing the proposals because of the harm to the registered park and Lions Gate setting, and I'm not satisfied that it's done so. So, if you like, if one asks the question, why is the inspector looking at alternatives, i.e. alternative sources of funding? It's because of that significant heritage harm which he found to arise, isn't it?
In that case, that's how it's sort of been put. Yes.
Yes. And if you sort of step back from the detail of this and think about the principles at play here, it's what entitles a decision maker to think about, and sometimes requires a decision maker to think about alternatives, is where there's significant planning harm arising. Because there's generally no other statutory or other obligations in a case like this to consider alternatives, is there?
No, yeah. No.
That's right, isn't it? And so it's not enabling development. So it's the guidance, the English, the Historic England guidance doesn't apply. There's nothing express in statute or policy which would require us to look at alternatives. And can I just push the point a stage further? Are you saying, is your evidence or your team suggesting that this inspector is required as a matter of law to consider the funding of all the alternative funding sources?
My personal view on this is that if you're going to be putting forward restoration works at Sion House as a benefit of the development, and it's not enabling development, you need to attribute weight to that benefit. The appellant has attributed significant weight to that benefit. So if you're attributing significant weight, then should the appellant not be thinking about how much these works would cost and whether they could be funded in some other way? Because if that funding is available and it's purely a question of how long the works would take and that they could be done in a different time scale, and yes, we accept that, heritage assets do degrade over time, and you know, the time is of the essence. But if there was another way that they could be funded and a different time frame, rather than a question of it couldn't be done at all, then I think we would expect other options to be considered and put forward as part of any reasonable case for significant weight to be given to that benefit.
Well, but that's wrong as a matter of principle if what you're proposing in order to deliver the cross-subsidy does not give rise to significant planning harm. Because unless you've got significant planning harm arising, you don't look at alternatives as a matter of course, do you?
I think it's a reasonable expectation for an appellant putting forward significant weight to do that. There's no requirement for them to do it, but I think if they are putting a case for significant weight, it is it's a landowner who has, we're aware of his vast portfolio, and on the back of that, I think obviously that should be considered, and it is relevant because it's to do with the funding that's available, and it's relevant to the weighting of the benefits.
So it's because of the particular applicant for planning permission that you think alternative funding sources should be considered?
It's not because of, but it's a relevant factor.
Well, it's the only factor you've mentioned.
Yes, it's a relevant factor.
The inspector will be well aware that the normal starting point in planning decisions is that the applicant for planning permission is irrelevant.
Yes, in that case, it usually is.
Yes, it is.
It is.
And so, just to test the proposition, you don't have to own land to make an application for planning permission. I can make an application for planning permission over
anyone can
garden
make an application. Like yes, exactly.
Yes.
Yes.
And so it's quite an important principle when you think about that and recognise that the particular applicant for planning permission is normally completely irrelevant to the exercise. And there are exceptions to that, aren't there? Such as where you want a personal planning permission.
Yes.
Right. But that's not the case here, is it?
That's not the case, no.
So what's happening here is that planning permission will attach to land. The Section 106 will bind the land. The normal position should pertain, which is that the applicant for planning permission is irrelevant to the exercise, I suggest.
I would maintain that I think it is relevant to consider that those circumstances of the landowner, because it's relevant to the funding available, and I would maintain that.
There's a bright line then of difference between us as to approach, because you're saying personal circumstances are here relevant, and we should be looking at alternatives, notwithstanding, even where there's no significant planning harm arising. That seems to be your position.
And there's no significant planning harm arising in heritage respects.
Yeah. That seems to be your position, is that personal circumstances are relevant and we can consider alternatives to the scheme, notwithstanding the absence of significant planning harm. Is that's your position, is it?
Essentially, yes.
Right. Cute. Well, I won't, obviously I'm not going to comment on your evidence. I'll deal with to the extent I need to in submissions. So let's talk about timing. Timing is everything. 10 to 3. There's a deteriorating asset in Sign House, isn't there, in the sense that the stonework at the building requires repair, doesn't it? Yeah. And all other things being equal, the quicker the repair, the better.
Yes.
In the interest of the heritage asset itself. Yes?
Yes.
But also in order to appreciate the heritage asset at its best.
Yes, the quicker it can be repaired.
Yeah. So there is a public interest in appreciating the significance of something other than a degraded asset. It's appreciating an asset in the condition in which it was intended.
Yes,
to be
that's the
seen.
merit, yeah.
Yes. And that's of real importance when you're looking at an asset which is as exuberant as Sign House. Because part of the point of it is that it's a very fine building to be enjoyed in tip-top condition.
Mm-hmm.
Yeah. And then thinking about the staterooms, we heard, and you've accepted that they're open to the public. You can have tours a couple of days a week, or you can go just and have a look yourself on Sundays, and that's from March to October, as I understand it. And at the moment, the public is viewing a degraded asset in the sense that some of the rooms, other than the ones which have been restored, are in a tired and sort of frayed condition. Have you been into the building?
Not for a long time, no, but I'm aware of colleagues have been there. So
I see. And all of that is sort of, for a member of the public visiting the building, it's missing the point really of a really flamboyant, set of rooms. They are lavish, and they're intended to be viewed again in top condition, aren't they? So that you understand what's important about them, which is a really significant architect having been given this wonderful brief to show off the taste and so on of the owners of the house. Yes,
of course, that's the benefit. Yeah,
in terms of if it takes, I mean, I'm not going to descend to specifics, but if it takes a lot longer to undertake the repairs, the restoration to the staterooms, people who might otherwise have seen and appreciated the building in the condition in which it was intended won't. I mean, actually, life is finite. There's only a certain amount of time, and so actually, it could be quite an important point, couldn't it?
It could be.
Yeah. Okay. So, and of course, all of that relates to one of the most important listed buildings in the country.
Yes.
Yeah. So we turn now to housing, and I think there's an outbreak of happy agreement here. Our agreement of significant weight to attribute to the delivery of market housing, that's because of government policy, which is to boost supply nationally, isn't it?
Yes.
And it's particularly critical in London, where the housing crisis can be seen very acutely.
That's correct,
yes.
Yeah.
And you attribute significant weight to this. You don't downplay the weight to attribute to this.
That's correct.
They're very welcome as far as you're concerned.
Mm-hmm.
That position is in marked contrast to some of the local politicians that we've heard, but you don't support what they say, nor the slightly dismissive approach they've taken.
The provision of housing and affordable housing, it does. I've obviously qualified it with the fact that Hounslow is doing well, and it's doing better than a lot of other authorities in terms of its housing delivery tests and AMR results. However, it has to be. It's clear from development plan policies that housing is in critical need, and therefore we have to give it significant weight.
Yes. And as far as affordable housing in particular is concerned, there's a mayoral guidance, an SPG, that's CD. D5, please.
Yeah. Okay.
And when you have D5, turn within it just to paragraph 6. The delivery
paragraph 6. Sorry,
of the SPG. Page 8.
Page 8. Sorry, thank you. Okay, it's just there's different sections. Yes, I'm there.
Paragraph 6. So, given the strategic importance of affordable housing delivery and the significant impact of reduced levels of affordable housing, you've actually got a call-in power, which the mayor is saying that will be exercised there. Yes?
Yes.
So important on a strategic level that the mayor will call in applications in relation to it.
Exactly.
And what the SPG is doing is setting a 35% threshold, so you can get a fast track if you're above 35%, and below it, it's viability threshold. And that puts into some context the 40% which is offered here, doesn't
Yes.
it? It well exceeds that, and it's policy compliant here, isn't it?
It's policy compliant here.
Yeah. And more practically, that's 32 new homes. Yes.
2 new homes, yes.
High quality homes in a sustainable location in transport terms. Yes.
Yes.
Yeah. And they would be affordable to people who need them.
Yes.
We've not heard that from those people at Enquiry. You don't, but it's not that they're not important, is it?
They are. All affordable housing is important.
Indeed. As far as the key worker housing is concerned, if you turn in your proof to page 59, you accept that the key worker housing is beneficial.
Yes. Yep.
But give it moderate weight.
Correct.
Yes. The housing would be reserved, you accept, for the trust, for the housing, the hospital trust.
That's it.
Yes. I mean, what that means, of course, is that they wouldn't have to compete on the market for to be able to secure housing for its employees.
Yes.
Yeah. And the Section 106 planning obligation, which we will look at in detail, so I'll just mention it briefly now. Its third schedule includes owner covenants. It defines key workers. It provides for a lease to be granted, and there's a requirement to provide a lease to the NHS Trust, isn't there?
There is.
There is. And so it will need to be on terms which the NHS Trust accepts, won't it?
Yes, it will.
Yeah. So that's the developer taking that risk in order to give a copper-bottomed guarantee of NHS key worker accommodation.
Yes.
So again, it's the developer assuming the risk, isn't it?
Yeah, the developer's assuming the risk.
Yeah. If you turn to CDA1, which is our appeal statement of case,
Yeah.
and within it to Appendix 7, which is at electronic page 373.
Sorry, if you just give me a moment. Thank you. Appendix 7. You said?
It's right at the very back of the document.
Yes.
It's page 373.
Yes, I'm on it. Yeah, thanks.
You got it. Oh, you've seen we've read this.
Yes, I've read it, yes.
Okay. They identify a need, don't they? I mean, take your point about the development plan not separately identifying this need, but the trust itself identifies a need, doesn't it, for this sort of accommodation?
It does.
It does. And they point out that suitable accommodation is in short supply. And you're not contradicting their experience, I don't suppose.
No, I don't
No.
have experience to
No.
counter that, no.
No, and their experience is such that what they do, they tell us, is they block book accommodation in order to meet the need.
Mm-hmm.
So in other words, this is not a foreign concept to them.
No.
They secure accommodation and they use it then to house their staff. Okay, so it's not a novel proposition. It's just that it's right next door.
Mm.
I mean, actually, it's quite an unusual situation here, which is that you have got immediate proximity to the hospital and a preparedness to offer them a lease over a large part of the accommodation. Quite an unusual set of
Yes, it's quite a
circumstances.
unique situation, yeah.
And clearly they identify it as beneficial and advantageous, don't they?
Yeah, they appear to, yeah.
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 Now, your point here in your 14.6 is that you don't understand the position to be that in the absence of the accommodation, the hospital would be understaffed and unable to provide enough key workers to perform its function. I just want to test that. I mean, if the NHS Trust came to this inquiry and said, but for these 30 units, we will be unable to perform our function as a hospital, it would be absolutely scandalous. Surely that can't be the right test to apply.
So, I mean, if they were to come and say it can't.
You're saying essentially I'm not going to give this benefit full weight.
Yes.
Because we're unable to demonstrate that the hospital would be understaffed and unable to provide enough key workers to perform its functions. I'm testing that proposition because it seems to me to be setting quite a high bar for getting significant weight for a benefit.
I think, I mean, that's one of the factors. I think the main point here that distinguishes it from other types of housing is the lack of an identified need in development plan policies and the lack of reference to that.
That's not what you said in your 14.6. Your 14.6 downgraded it from substantial to moderate because the hospital wasn't coming along saying we're unable to perform our functions without this housing.
Yes, I mean that was the position there, and I still maintain that position.
But borough-wide, you might very well be right. But this is an application which is responding to its very local context with a need expressed by a very local employer. It does seem to me to be beneficial, particularly and unusually beneficial in that the lease is offered without more.
Yeah, that's a position. I don't agree. I still, in my professional opinion, think that given that it's not underpinned by any sort of policy, and we haven't seen any evidence that actually says that it won't function, I do think that is a reasonable case to downgrade it to moderate. It's a point of disagreement.
Turning to economic benefits, I think you've accepted the moderate benefit there. As far as the route between Snowyfield Away and the All Saints Church and the surfacing of that route, I mean that's simply providing an accessibility benefit within the local area, isn't it?
Yes.
I mean, what one should do when you're designing a scheme is, I hope not to be teaching anybody to suck eggs here, but you should take the opportunities available to make places better for people. That's the advice. And this is what the appellant is doing.
Yes, in a moderate way, in a way, yes.
Yes.
It's giving us a small benefit.
Yes, in relation to that, it is. Although at 14.24, you took a harder line. 14.24a, you said you didn't understand how improvements to the All Saints Church driveway are related to the development.
14.24. The All Saints Church access, I mean, it's not related to the development because it's outside the site.
Literally just been talking about that.
Sorry, so I think I was talking on cross terms. I was thinking about the Church Road access. Sorry, that was a misunderstanding. I'm sorry about that.
I put both to you. My suggestion is that the inspector reads that in the context in which we've just had our exchange, and I'll make submissions on that basis. I'll move on now to biodiversity net gain. You don't contend, do you, that there's any breach of GB7 in the local plan?
I don't contend that.
No. And when the inspector's thinking about what weight to attribute to providing 10% biodiversity net gain, I mean, is it your understanding that the government's looking to encourage biodiversity net gain?
Absolutely, they are.
Yes. I mean, if developers, in the sort of general principle, I'm not here talking about the applicant repellent, but as a general principle, if you don't get credit within the planning balance for the delivery of 10% now in the absence of a requirement for it, there's no commercial reason to deliver it, is there?
There's no requirement to deliver it in this scheme.
No. So, in other words, in order to incentivize developers it would make sense, wouldn't it, to give them proper credit within a planning balance where they provide more than the basic requirement?
Yes.
Yes. Whereas your approach, which is to give very limited weight, doesn't achieve that objective, does it?
It does give some weight to it. It's very limited weight.
Okay.
And I've explained why.
But it would hardly act as that incentivization to provide 10%, would it? In the way that clearly the government would intend.
I think that, given the fact that this 10% is only just about being met, and it's not necessarily being met on site, as we can see from the Section 106 agreement,
Yes.
there's a clause to deliver it off-site if it
Yes.
can't be done, or
Yes.
by payment.
Yes.
I think, given that there's no significant exceedance of the imminent policy threshold that's going to come in with the Environment Act, I can't give that much more weight to that benefit.
Well, I note the disagreement between us. I also note the time. So that completes the questions that I wanted to ask Mr. Hall. Thank you very much indeed. Thank you, Mr. Hall.
Thank you very much.
Mr. Grant, would you rather have a break and carry on with re-examination, or?
I say only. We've only been going for an hour since lunch.
Okay, that's
so long
fine.
as Mr. Hall doesn't indicate he'd like a break, then I'm happy to carry on.
I'm absolutely fine to continue.
Okay, in that case, please carry on.
Thank you very much indeed. Mr. Hall, we'll start with questions that you asked this morning and work our way forward into the afternoon. You were asked this morning about differences between statutory allotments and non-statutory allotments, and the issue about protection. Do you remember that?
Mm-hmm.
Where a piece of land is designated as local open space, what does that do or not do in terms of protection?
The statutory nature.
Yeah, what does designation as local open space achieve in terms of protection?
That achieves a level of protection that's underpinned in development plan policies.
And to what extent is that level of protection relevant or irrelevant in terms of the promotion of alternative uses on a site?
It's relevant.
Yeah. Next, please. You were asked about the questions arising from an extract in the DAS at page 62. Do you remember about cultivation, uncultivation, and vacancies in 2016? Do you recall that?
Yes, I do. Yes.
And you, in your responses to those questions, drew attention to the ACV judgment. Do you recall that?
I did. Yes.
Can I just ask you to take up that judgment, please, which we've got at core document G1?
I have it. Yes.
And can you go, please, to paragraph 9?
I'm there.
And first of all, so far as vacancies are concerned, how many vacancies, both numerically and in terms of percentages, did the judge note at paragraph 9?
The judge noted that there were 11 vacant plots, varying sizes, and that equated to 22% of the available plots.
And then can you turn forward, please, to paragraph 31?
Yes.
What percentage of the land was identified at that time by the judge as being occupied?
78% of that land.
Now, it was put to you, you had a series of questions put to you in the context, I think, of building up to and then explicitly within the topic of fallback. And I just want to ask you some questions about that. It was brought to your attention that so far as licenses are concerned, do you remember my learned friend said, well, at the time of the previous appeal, there were licenses in place, and there's a material difference now because there are no license. Any access in is unlicensed.
Mm.
So far as the unlicensed access that is going on more recently and now, as you understand the position, is that unlicensed access permitted or not permitted?
It's permitted.
And can you take up, please, the decision letter?
Yes.
And can I take you, please, to paragraph 42?
Yeah.
And you'll see in that paragraph, you can just remind yourself of it, but can you see the inspector there refers to the grant of new licenses at that time?
Let me just read it quickly. Yes.
What did the inspector note about the duration of the licenses that were being granted at that time?
They were short duration. They had a short duration.
Yeah. And so, in terms of the move from short-term licenses to unlicensed permitted access, what do you say about how significant a change that is for the purposes of the fallback position?
It's not a very significant change.
And sticking, please, with the decision letter, can you turn to page 48 on the following page?
Page 48. Oh, paragraph 48.
I'm sorry, that's my mistake. Paragraph 48. You'll see the inspector refers to the appellant's assertion about closing the allotments.
Yeah.
And makes the point, we've referred to it before, but since that would be in nobody's interest and would hardly add to the record of good custodianship of its land in the area. Do you see that?
I do.
So far as that factor is concerned, is that a factor which has changed or differs now from then, or in your view, is it substantially the same?
I think it's substantially the same.
It was put to you again within this same topic about the intentions of the Duke. Do you remember? And it was suggested to you that it was put both in opening and that it was in Learner Friends instructions that the allotments wouldn't allotment use wouldn't continue if the appeal failed.
I do.
Can you take up, please, the appellant's statement of case?
Yes.
And can you turn, please, to paragraph 4.9 on page 16?
Yep.
And can you look at numbered paragraph 1?
Yep.
And you see 3 lines from the bottom. The appellant says there, the existing allotments were non-statutory and could be closed at any time as they now have been. Do you see that?
Yes.
Now, 2 questions arising that. First of all, as they now have been, do you understand that to have been factually correct or incorrect?
That's incorrect, I find.
And so far as the first part of that sentence, that they could be closed at any time, do you interpret that as being the same or different from an assertion that they will be closed?
It's different.
And then can you take up, please, Mrs. Roberts' proof of evidence?
Yep.
And can you turn, please, in her proof to paragraph 7.37?
7.37.
So it's on internal pagination, page 51.
7.3 of her proof.
Her proof, 7.31.
Oh yeah, sorry, I think I was on the wrong thing.
7.37, sorry.
7.37. Thank you. Sorry about that.
Do you see on page 50 under the subheading planning benefits?
I do.
You see that?
Yeah.
And can you see numbered paragraph 2?
Yeah.
And the second sentence, the existing allotments were non-statutory and could be closed at any time as they now have been. Do you see that?
I do.
So does that mirror or different from the position expressed in the statement of case and the position you commented on a moment ago?
It mirrors it.
And then can you turn, please, to Mrs. Roberts' rebuttal at paragraph 2.16.
Yes.
And if you follow down in that paragraph, please, 4 lines, you'll see Mrs. Roberts wrote, the Park Road allotments are private and non-statutory and cannot be relied upon for allotment provision unless this appeal is allowed. Do you see that?
Yes.
And where Mrs. Roberts said it cannot be relied upon, as you read that, does that indicate that they will be closed in the event of an unsuccessful appeal?
It doesn't say that they definitely will be, no.
At the conclusion of the a series of questions about the fallback position, do you remember an exchange where you, I think, wanted to add something, and the learned friend said, well, if there's anything to add, it can be done in re-examination if necessary.
Yes.
Do you remember that?
I do.
It may be highly risky to ask you to remember something you were planning to say about 4 hours ago. So I'm not sure I'm going to do that. But what I will do is to say that having had the series of propositions put to you in cross-examination as relevant factors, as the appellant would have it, in the context of the fallback position, does that alter the conclusion you'd reached earlier, or does the conclusion remain the same as to whether or not you take the view there's a real prospect of there being no allotment use on site in the event of an unsuccessful appeal?
I continue to feel it's a theoretical situation at best. I think the reasons were raised at the evidence in chief yesterday.
Fine. Next topic, please. You were asked some questions about Green Lane and James Street, and I think in particular you were taken to the, I think it was the allotment strategy.
Yes.
It's E3. I think that was the document, but my note may have be failing me on that.
Don't think it was, actually. I think it was the open space background paper. From memory.
Yeah.
E2. Core document.
Thank you. So will you bear with us while we, between us, find the reference? I'm going to come back in a moment whilst I look to my left for that reference to be found, please. You were asked questions about plot sizes. Do you remember?
Yes.
And you, in one of your responses, referred to the statement of community involvement.
I did, yes.
All that. And in particular to the answer, I think, along the lines, we want the same size plots as we have now.
Yeah.
And what was put to you was, well, that doesn't tell us that people want larger plots. It's telling us that they want the status quo. Do you remember that exchange?
Yes, I do.
A couple of questions arising out of that. First of all, we heard, didn't we, from a number of plot holders on the first day of this inquiry. Did you understand from those that spoke to the inquiry, did you understand them to be experienced allotment users or beginners?
I understood them to be experienced users.
Yeah. And so far as the sorts of plot sizes that are being proposed through this appeal scheme, are they, as you understand the position, are they more appropriate for experienced plot users or for beginners?
For beginners.
Still on the subject of plot sizes, can you turn please to your appendix 3B?
Yes.
And in 3B, that is the document which is the National Allotment Society's policy 101 for plot sizes. Do you see that?
Yeah.
And can you see numbered paragraph 3,
Yeah.
which talks about large plots being a source of frustration, and that's a principle that was really put to you during this part of the cross-examination.
Yeah.
Do you recall that?
Yeah.
And you'll see towards the end of that paragraph a sentence which refers to the subdivision of plots that have fallen vacant. Do you see that?
Yeah.
2 questions. Read that sentence yourself, and then I'm going to ask you 2 questions about it.
Yeah.
First of all, not just with the appeal site, but in Isleworth and Brentford, what do you say about whether or not that is characterised by allotment plots falling vacant?
Sorry, could you just
Yeah, for both the appeal site and in Isleworth and Brentford more generally.
Yes.
What do you say about whether or not there is a characteristic of allotment plots falling vacant?
There's very few vacancies in Isleworth and Brentford, and historically the site was quite well used. Was very well used.
And where the sentence in this policy refers to the subdivision of plots,
Yes.
Does that identify that as being a short, medium, or long-term response where there are waiting lists in operation?
That's a short-term response to waiting lists.
Whilst we have opened the National Allotment Society extracts that are in your appendices, you were asked in cross-examination about their status. Do you remember? And you referred to them as being guidance.
Yes.
As guidance documents, what weight do you say the inspector can and should give those in the context of this inquiry?
I think they should be given moderate to significant weight.
So far as the size of plots, do you remember you were picked up, I think, on referring to 60 square metres, and you were taken to the point that actually they're 57 to 78 square metres is the range?
Yeah, I recall that.
So far as that range is concerned, how significant do you understand the difference to be between a plot which is at the bottom end 57 and 78 metres at the top end?
It's an extremely narrow range, which effectively does not present variation in plot size, in my view.
And at the top end, at the 78 square metres, so the biggest one that would be on offer, is that, as you understand it, a size which is more suitable for beginners or for experienced plot users?
More suitable for beginners. Still falls well below national recommendation.
Thank you. You were asked about the allotment strategy, and can you take that up, please, at document E3? And you were taken to the list of sites, do you remember, which begins on page 10 and continues on to page 11?
I do.
And there was a suggestion put to you, do you remember, in terms of the compilation of that list, a suggestion that it reflected statutory rather than non-statutory allotments, and you said you think it relates to council-managed sites.
That was my interpretation of it. Yes, I do remember that. Yeah,
and you were pressed a little bit on that.
I do remember.
Can you turn to the front of the document, please, in the foreword?
Yeah.
And do you see there in the very first line in the foreword, it says Hounslow has 29 managed allotment sites.
Yeah.
Is that consistent or inconsistent with the position that you understood, which was that the sites at table 2 are Hounslow managed sites?
I think I see that to be consistent with what I said.
And then can you turn forward in the document, please, to page 6? And can you see this is the chapter headed Allotments in Hounslow? And we see the figure of 29. What does that relate to?
That relates to allotment managed sites.
And if you turn back to the list that we had at page 10, I'm going to trust your counting to be quick and good. How many sites are there on that list?
I see 29 sites on that list.
Yeah. Next, please, you were asked some questions about Grampian conditions, and I'm not going to stray too far into that because we're reserving, as you know, the principal discussion on that until tomorrow. But one of the points was put to you, do you remember, was about the fact that the material that's actually in the council's knowledge in terms of dealing with that issue. But just to help us a little bit on that proposition, can you turn please to core document A24? And that is a document submitted to the Planning Inspectorate in July in setting out what were at the time the outstanding points as between the appellant and the local planning authority in respect of the Section 106 agreement. Do you see that? And can you turn to the second, to the bottom of the first page, first of all? That sets out, doesn't it, the respective position of the parties in respect of the proposition that was being floated at the time for off-site allotment provision. Do you see that? Yes. And on the second page, halfway down the page, in respect of that potential obligation, you'll see the appellant's position set out, which begins the appellant does not consider. Do you see that? What does it say?
Says the appellant does not consider that any land is currently available for an off-site allotment scheme that would satisfy the council's stated requirements.
I'm going to return to the point that I moved on from a moment ago because I couldn't find the reference, which was in respect of Green Lane and James Street. And can you take up, please, the 2018 open space study?
Is it the open space study? Actually, it is that one, isn't it?
Yeah, the 2018 one.
Okay.
And can you turn on the internal pagination, please, to page 59? And you'll see there a paragraph you were taken to at the bottom of the page in respect of Green Lane. You see it says it's understood to have not been in use as allotments for around 30 years.
Yeah.
And then the first paragraph on the following page in respect of James Street, the final sentence of that paragraph, that James Street site is understood to have not been in use as allotments for over 20 years. Do you see that?
I see that.
Now, so far as those, as a matter of fact and degree, in terms of those sites being out of use as allotments, do you regard those as being comparable or not comparable to the position at the appeal site?
Not comparable.
And one of the points that was made during cross-examination was that the principle about where a site is out of use and the approach taken to James Street and Green Lane. Can you have a look, please, at the following paragraph from the one we were just looking at, which refers to Heath Road?
Yeah.
And we see there that Heath Road allotment is identified as a site which is not currently in use. Do you see that?
I see that.
And it's in your proof. The paragraph number, I think, is 12.38, but I don't think you need to turn to it to answer the question, which is, although Heath Road allotment had been out of use, what was the council's approach to that site within the last year or so?
It was to bring that site back into use, which it is now with 44 plots.
Next, please, you were asked some questions about design. Do you remember you were taken to the MPPF and some questions about whether or not design should be given significant weight?
Yeah.
Just one question arising out of that. Supposing the inspector gave the matter of design significant weight as a benefit in the planning balance. In your judgment and on your balancing, if that was given significant weight, would that materially alter the overall planning balance?
It wouldn't, in my opinion, no.
Next, you were asked some questions about policy compliance, and can I ask you please to take up the previous appeal decision letter, and can you turn please to paragraph 64? And firstly, in terms of, do you remember one of the themes that was taken with you on this issue was, well, you haven't set out in your analysis, or the council haven't, the policies that are actually complied with, in addition to the policies that aren't complied with. Do you see that? Now, first of all, what did the inspector have to say in the first sentence of paragraph 64?
He said that just because there are possibly a greater number of policies within the development plan that the proposal would comply with than policies, it does not mean that the development is acceptable.
And first of all, do you agree or disagree with that proposition?
I agree with that
Thank you.
proposition.
It was then put to you that, as a proposition, that if the scheme complies with important development plan policies relating, for example, to heritage and design, that I think it was being suggested that affects the judgment as to whether or not the scheme is in conflict with the development plan overall on account of conflict with local open space policies. Remember that?
Yeah, I do remember that.
What do you say as to whether compliance with other policies such as heritage and design means that a scheme which results in breaches of local open space policies should therefore be regarded as being in compliance with the development plan overall?
It does not mean that, in my view.
You were asked some questions about your involvement at the application stage, and in particular arising, do you remember, from paragraph 1.3 of your proof of evidence? And you were taken to task a bit about whether or not you were right to say that you weren't involved in the application stage or the application determination. Did you have any? Did you express any professional judgments or have any professional input yourself into the officer report at the application stage or its conclusions?
I myself had no involvement in that.
Next, please. You were asked some questions about Scion House and the repairs. Can we take up again, please, the decision letter? Yeah. And can we go to paragraph 26, which is a paragraph to which you were taken in cross-examination? And we can see that, can't we, in the collection of paragraphs beginning at paragraph 23. Do you see that?
Yes.
Now, we can see, can't we, in the first sentence of paragraph 23, the inspector writes there, the cumulative harm should be weighed against the public benefits of the proposals. Do you see that? If the inspector here were to reach the conclusion that the proposal was in conflict with the development plan overall, what do you say as to whether or not the inspector ought to weigh that conflict against the benefits of the scheme? Correct approach or incorrect approach?
It's correct to weigh it against the benefits, yes.
Yeah, and in terms of weighing those benefits, what do you say as to whether it's correct or incorrect to ascribe as a matter of judgment a particular weighting to each of the benefits that's relied upon.
Yeah, so that's reasonable.
And if you turn, please, into the decision letter at paragraph 26.
Yeah.
In respect of the repairs which were being promoted as a benefit in that appeal, where the inspector wrote in the final sentence, whilst this would be beneficial, I consider such a benefit to be relatively minor and did not therefore attach great weight to it.
Mm-hmm.
As a matter of principle, in not attaching great weight to that benefit, is that consistent or inconsistent with the approach that you set out in relation to this scheme?
That's consistent with the approach I've taken.
Yeah. In answer to a series of questions in cross-examination about this topic, you referred to two factors. One was whether or not there are other ways of funding. In terms of the weight that should be given to this as a benefit in the planning balance, what do you say as to whether it's appropriate or inappropriate for the inspector to consider whether or not there are other ways in which the repairs could be funded?
I think it's appropriate for them to do that.
What do you say as to whether it's appropriate or inappropriate for the inspector to consider whether the works could be done absent the development funding?
I think it's appropriate to consider that.
Next, so far as the key worker accommodation, please, is concerned, you were picked up on the rationale for you moderating the weight from significant down to moderate. Do you remember that?
I do. And
it was put to you that your approach, in particular in respect of your comment about whether or not it affects the functionality of the hospital, that presents a very high bar. Do you remember that?
Yeah.
When you're weighing matters in the planning balance, what do you say as to whether or not significant weight should or shouldn't represent a high bar?
In terms of housing, sorry.
No,
wait,
it's
sorry.
a general proposition.
Okay.
What do you say as to whether in the planning balance, whether a particular consideration is given significant weight should be a high bar?
Yes, it should be a high bar.
Yeah. Lastly, please, you were asked some questions about biodiversity net gain. And it was put to you, I'm sort of paraphrasing really, that the approach that you were taking was inconsistent with the government's aspiration to incentivize developers to provide biodiversity net gain. Do you remember those questions?
I remember those.
There's a couple of things arising out of that. Firstly, in your approach to the weighting of biodiversity net gain in this case, does your approach give credit to the developer for the biodiversity net gain which is would be provided?
It does give some credit to that.
Second, the approach that you've set out, which is the more gain, the greater the weight. The more gain, greater the weight. Is that consistent or inconsistent with incentivization to developers?
I think it's consistent.
Yeah. Good. So those are all my questions in re-examination.
Thank you.
Thank you. Thank you very much.
Sorry, I must put the microphone on. That would be better. Perhaps we'll hopefully have time for examination in chief of Miss Casey before we finish, I'm hoping.
I'd hope to get further than that.
Good. Okay,
honest.
that's fine. Okay,
But
well,
let's
on
say-
that basis, shall we Yeah.
In the interest of time, I'm happy if that's just heard in that way, if that's appropriate. I do appreciate.
Okay. Okay. Thank you for that. Yes, I can assure you that both your written representation and all the others that have been submitted are considered by me, and so thank you for that. Okay, shall we adjourn briefly then? Is 10 minutes too short? We'll aim for 10 minutes and see where we go. So the inquiry is adjourned then till 10 to 4, and we'll restart then with examination in chief of Miss Casey.
Sir, just one matter.
Yeah, go on.
Myself and the Park Roads Allotment Association had discussed the next witnesses. We've not had the opportunity to float this with the appellant, but we were proposing that it might be more logical in terms of the issues for Mr. Stephen Hurton to go next, followed by
Fine.
Miss Casey, if that's okay.
I'm personally quite happy, however order you want to play it, that's fine.
I'm grateful, sir.
Okay. is reconvening, and we'll start with Mr. Hurton on behalf of Park Road Allotments Association.
Can I just ask a question? I hope it's not a stupid question, but is it intended that Mr. Hurton is speaking to the proof that was submitted?
That's correct.
Thank you.
Ms. Devon.
Good afternoon, Mr. Hurton.
Good afternoon.
So just to introduce you to the inquiry, you're Stephen Hurton.
Yeah, I'm the chair of the Park Road Allotment Association, and I've held that role since about 2016.
I understand you're also an allotment holder yourself.
I am an allotment holder myself, and as chair, my role involves, along with our secretary, Annie Aloysius, discussing with the estate all the matters and the consultations on behalf of the allotment holders.
How long have you held your allotment for?
I've held my allotment since 2014.
And what size is it?
Mine, I'm still unfortunately on a starter plot, which is approximately 40 square meters of croppable space.
That is quite a bit smaller than the rest of the plots on site, or what would be considered as a full-size plot. So could you please help the inspector with how you came to acquire that particular plot?
I got my plot through an initiative through my predecessor, who turned two full-size plots into starter plots, and along with Jane Perry, who gave evidence, who started on a starter plot. We started there, and Jane managed to get a full-size plot. And of my 40 square meters, I can grow some annual vegetables. So, for example, spring onions, beetroot, but it's very difficult. You couldn't, for example, grow potatoes or overwintered brassicas just because of space, and you've got to be very careful of what you do grow.
So if we're sticking with then a compare and contrast exercise of plot sizes, so to speak. So you've just said what's possible to cultivate on your size plot. If we go to a full size plot, 250 meters squared, what can be cultivated on that size of a plot?
Well, with a plot that size, you can be self-sufficient easily, and you can have enough room for your shed and to store your produce, to store your tools, to store your pots, and to store your compost, etc., etc. Whereas when you're on a starter plot my size, I've got my compost heap in an unused plot next door to that, and I leave my tools at home, and I take them with me each time I come, and I germinate all my seeds and leave my seed trays at home, and then plant them out when there are plugs, when they're germinating, they're sort of 2 or 3 inches high.
So if we do the same exercise with a half-size plot, so the 125 meter square plot, what would an allotment holder be able to cultivate on that size of a plot?
With something at 125 meters squared, it'd be very difficult to be self-sufficient. You've got to choose your crops, but it gives you a lot more scope than where I am at the minute. So, for example, you can have potatoes, you can have your beans, you'd have enough space for your brassicas and your overwintered stuff. You probably have enough space for asparagus and your perennial vegetables, as well as fruits and fruit bushes and fruit trees.
And then finally, on plot sizes, if we move to what the appellant is proposing, the 60 square meter size plots, what would a plot holder be able to cultivate on that size plot?
Well, it'd be very difficult. It's a bit like where I am at the moment, because by the time you've got your shed on there, if you're having a personal compost bin, which I prefer because it allows me to manage my compost how I want it, which means I get the right mix of green and brown waste, and I can turn it when I want, and I can use the resulting compost on my plot as fertilizer because I grow organically. It takes up a significant amount of that 60 meters plot, which means that you're only left with probably about 80% to grow on, which you're nearly down to 40 meters squared, which then gives you all the restrictions that I've just explained. And you have to make a distinct choice on what crops you're going to make, and you're essentially doing short-term, quick-growing lettuce, spring onions, that type of cropping.
Thank you. If I could just ask you perhaps, and I'm guilty of doing this myself, Mr. Hurton, just to slow down a tiny bit because the inspector's hand might be very sore trying to keep up with you.
Yes.
Thank you.
Sorry about that.
Not at all. If we move on now to the history of the site, not going back 100 years, but the recent history, in effect starting with 2015. And if I could ask you, please, Mr. Hurton, to turn up the appellant's proof, CDA8, and if we could go to Appendix 1 of that proof, please. And if we could go to paragraph 5.1, this is the appellant's statement. Let me know when you're there.
Sorry, excuse me, I got the wrong document.
No problem. It's Appendix 1 of the appellant's proof. This is the statement.
Thank you. Yeah, I'm there.
And it's paragraph 5.1. So we can see here that the appellant says, at the time when they were brought back into NE management in 2015, it was clear that the site was poorly managed and maintained, and many of the plots were either partly used or unused and overgrown. What is your position, Mr. Hurton, on the reality on site in 2015?
In 2015, the site was well loved and well used, and I think the best proof for that, which has already been mentioned, is the ACV judgment, which says there was 78% of plots were in use, and there was only 11 plots of varying size which were vacant.
And just on the ACV ruling, if I could ask you to turn that up, please. It's core document G1. And the paragraph, the 78% statistic you just referred to, Mr. Hurton, that's paragraph 31. But if I could ask you, please, to turn to paragraph 9.
Yeah.
Do you recall a conversation my learned friend had earlier with Mr. Hall, where she put to him that at the time when the appellant took the plots back into management, there were 11 vacant plots on site? Do you recall that conversation?
I do.
And my learned friend put it to Mr. Hall that these vacancies, these 11 vacant plots, were full-size plots. If I could ask you, please, just to read the last sentence of paragraph 9 of the ACV judgment.
Yeah, it says there are 11 plots of varying size, which represents 22% of the available plots.
So on that basis then, was my learned friend correct or incorrect to say that it was full-size plots, 11 full-size plots that were vacant?
Incorrect.
And comparing then the statement we've just looked at in the appellant's statement about the state of the allotments in 2015 with the ACV tribunal's findings we've just looked at, which in your view is the more accurate account of the level of cultivation and use of the allotments in 2015?
The ACV judgment is the most accurate by far.
And why would you suggest to the inspector that that evidence is to be preferred?
Because that evidence is based on, the evidence of a survey conducted by Northumberland Estates of the usage has a little disclaimer saying that it's inaccurate. It could be inaccurate at the bottom, and it also says their methodology is talking to plot holders on the way round, which I personally have been there and never had a conversation. And I spoke to our secretary about that, and she confirmed that she was in that position. And we've never, as representatives of the association, ever gone round with anyone from the estate doing a survey of usage of the plots.
So if we could just perhaps just might assist the inspector to have that reference you've just taken us to. I understand that's from the design and access statement. That is core document B1. And so if we could turn that up, please. And the relevant paragraph there is 3.32. So do you recall the conversation my learned friend had earlier with Mr. Hall as well? We're referring to the use survey that's referenced in this paragraph. My learned friend said that this is the best evidence that we have as to what was being cultivated on site in 2016. Do you remember that exchange?
I do, yes.
And we can see here at 3.32, the disclaimer you mentioned is at the bottom of the page. And what would you invite the inspector then to draw? Perhaps if you could read it out.
Well, sir, the point which I was referring to is in the bottom right-hand corner. It says, note, we recognise the fact that the survey may not be 100% accurate. It was, however, important in helping us to understand the usage of space.
And what is your understanding, Mr. Hurton, of the methodology that was used for the survey that my learned friend says is the best evidence we have?
Well, I think it's not particularly strong methodology because, as I said earlier, we weren't involved at all in the survey, and I personally haven't spoken to anyone conducting a survey about usage of the plots.
Are you referring to the second paragraph of 3.32 there on that methodology?
No, I was just referring to my personal opinion.
Sorry, can I just check the reference, please?
Yes, it's 3.32 of the design and access statement.
Yeah.
CDB1. Reference to the allotment use survey.
Thanks very much indeed.
So could you just read out the first line of that paragraph, please?
I can. It says, through conversations with allotment holders, it became clear that not all users actively cultivate their plots to grow fruit and vegetables. Many users enjoy having the space to sit and relax, to grow flowers and look after fruit trees. They also enjoy visiting the allotments with their families.
And Mr. Hurton, could you assist the inspector with what happened during those conversations to the extent you're aware?
Well, from my perspective, I never had a conversation, and the only person I've verified that with is Annie, but she's never had a conversation either about the site usage.
So sticking with this paragraph then, 3.32, we can see here that the appellant says that not all users actively cultivate their plots to grow fruit and vegetables. Many enjoy having the space to sit, etc., the line you've just read out. Mr. Hurton, do you share the appellant's conclusion of what constitutes active cultivation?
No, but active cultivation can include various different things. It can be fruit trees and fruit bushes, perennial vegetables, so for example, asparagus and rhubarbs, and then also your annual vegetables, which require the plots to be dug over and plantings to be made on an annual basis. So the perennial vegetables will be there consistently and will need managing in a different way to the annual crops.
What do you say, Mr. Hurton, about the role that growing flowers plays in cultivation?
Well, flowers, lots of people grow flowers as well as fruit and vegetables, whether that be for pollinators or whether that be for cut flowers to put in there, to take home, to put in there to display.
And in your 7 years as chair of the Allotment Association, in your opinion, have plot holders been actively cultivating their plots?
Most certainly, and I think that was apparent when you visited the site on Tuesday, sir.
And sticking with the topic of cultivation, could you please describe for the inspector the level of investment and forward planning that goes into cultivating a plot over a number of years?
Well, it requires a lot of dedication, and in line with Hounslow rules and allotment rules and National Allotment Society guidance, we should be having 80% cultivated to make use of the space.
And since the appellant took over management of the site in 2015, have allotment holders been able to plan and invest in their plots in the way you described?
No, not at all, because we've had we've had short leases and we've had no reletting of plots, and we've had a threat of closure and the threat of development ever since then.
We'll go through that chronology of events fairly shortly, Mr. Hurton. The appellant it's accepted that the appeal proposals would result in a reduction of 71% of the current allotment space. That's undisputed. However, if we could turn up the appellant's statement of case at core document A1, paragraph 4.61. We can see here that the proposed reallocated area, it is said here it will present an area equivalent to that under cultivation in the period 2016-2020, as evidenced by the allotment use survey we've discussed. Mr. Hurton, what are your views on that?
Sorry, I can't get to a reference, but my views are that the survey isn't representative, and that people, when we've conducted our own surveys of allotment holders, we as a group require significantly more space, which we've made the appellant aware of.
Now, on space, the appellant says that they will re-provide 38 plots on a like-for-like basis. And what is your opinion on that?
It's only like-for-like on a numerical basis. From a space basis, it's very significantly diminished, and there are 38 plots of 60 meters squared.
Just on the point I took you to about the appellant saying they will re-provide an area equivalent to the area under cultivation in 2016 to 2020, it might just be helpful, Mr. Hurton, just to take up paragraph 8 of your proof on that, please. And if you could read out the first line of that, please.
The appellant's contention at 4.61 of its statement of case that the appeal proposal presents an area equivalent to that under cultivation in the period 2016 to 20 as evidence in Park Road Allotment Survey 2017 to 21 fails to recognise that this survey was taken at a time of great uncertainty regarding continuation of the allotment, which led to an understandable reluctance to cultivate on the part of some allotment holders. This uncertainty arose from the appellant's first application from planning permission and subsequent appeal, and notices indicating imminent closure, short leases are causing uncertainty of harvesting, and the COVID pandemic and the associated lockdown.
Then sticking with this, as you call it, period of uncertainty, could you help the inspector with what you consider were key events, essentially, between 2016 and 2021, which to you illustrate what you mean by this period of uncertainty?
Well, since 2016, we had, in 2015, we were made aware of the estate's intention to develop it. In 2019, we had a notice to quit. In 2020, we were invited to a consultation with a view to the allotments being closed that year. And in 2021, we also got a notice to quit with giving us 8 days notice to vacate by the end of September of that year.
And so if we move on to a linked topic to the question of uncertainty, you deal with the issue of vacant plots at paragraph 26 of your proof onwards. If I could ask you please to turn to that, Mr. Hurton.
Okay.
And in the first line of paragraph 26, you refer to the appellant having a policy of dereliction by design. Could you assist the inspector with what exactly you mean by that phrase?
Yeah. Dereliction by design to us meant only being offered short lets, not reletting plots, and a breakdown of communication with the landlord, which, taking each one in turn, the short leases meant that it made it very difficult to plant crops, because if you don't know whether you're going to harvest them, what's the point in growing them? So, for example, if you're planting Brussels sprouts and your lease ends in September, you're planting them in April, May, and you're looking to harvest them in January, February, and March in the Hungry Gap. The same with purple sprouting broccoli. If you are talking about investing and growing in asparagus, which takes 3 years before you crop it, and then you can crop it every year during that Hungry Gap at the start of the year, there's no point doing it when you've only got a 6-month lease. So it makes it very difficult to grow, and it then also restricts you to fast growing crops, spring onions, lettuce, basic vegetables.
And sticking with the point of dereliction by design.
Can I carry on that, because
of course, sorry, I thought
I've also the two other points. One was not reletting the plots, which makes it very difficult from both a security point of view on the site, because very soon the plots become overgrown. It makes people feel awkward and uncomfortable. And the breakdown of communication leads to a distinct feeling of uncertainty and a lack of management in terms of cutting the paths and things like that. Makes growing very difficult.
So moving swiftly on then in the chronology to, I suppose, what we could term the present day. We're all agreed that the licenses expired in September 2021. But how is the site used and cultivated today?
Well, everyone is cultivating with gusto, and a lot of people would like to see the site better used, and a number of allotment holders have made a plan with other people and other growers to use the space, because there's a lot of people would like to grow and make the most of the space and use it for planting vegetables.
When you say everyone, Mr. Hurton, it might just be helpful to quantify that a bit more for the inspector. What do you mean by everyone?
Well, there's a lot of people, as shown by the waiting list, that locally want to grow produce and don't have the opportunity to do so in our area.
It might be helpful at this point to turn to page 22 of your proof. And at page 22 to 24, you include a summary of what you term the plot holder requirements and usage summary at June 2023. Let me know when you're there.
Okay, I'm here.
Mr. Hurton, what does this survey and the table on page 23 and 24 represent?
It shows the results of an informal survey conducted in June of this year, which showed that there were 33 individual families using the allotments, with a number of them being there for a significant amount of time. And it showed that the plot holder requirements had gone up from 2020 when we initially surveyed everyone in response to the consultation, so that now with the people who are using the plots, we'd need the equivalent of 24, 25 full-size plots for current requirements, let alone future requirements.
How did you gather this information?
That was an informal survey conducted between ourselves as a Park Road Allotment Association, which was spearheaded by Annie Aloysius.
And what are you inviting the inspector to conclude from this table and survey?
That the allotments are well used and well loved, and there are more and more people that would like to grow, and with proper management, they should be completely full, like the rest of the allotments in Hounslow.
If you could just turn over 2 pages to page 25 of your proof, Mr. Hurton. There's a copy here of some email correspondence between yourself and the estate. And it refers to Syon Park Allotments cleared area. Could you help the inspector with what this email was discussing?
Yeah, this was myself and Annie were invited to meet with the estate at the start of the year with a view to clearing 2 plots which hadn't been used for quite some time and putting them back into cultivation, which you will have seen on the site tour area in the bottom corner. We put in quite a bit of effort to meet and discuss that, and we all agreed to go ahead, get that done. All the plot holders were in agreement. We got permission to do that because all the trees have got preservation orders, so needed permission to do that. But unfortunately, at the time, the estate missed the dry February, and so it got done in the very wet March. And so the plots were cleared, and unfortunately, to date, they still haven't been let out. We were told there'd be new licenses issued for those plots, but nothing has happened bar them being rotivated to keep them tidy, wood chip put around the edges, and weed killer applied around the outside to kill any of the trees which were around the border.
Why did you feel it was important for the inspector to know about these cleared plots?
Because it goes a little bit against the fact that in the appellant statement of case, we went in occupation on the site in their proof where they're only by the goodwill of the estate, and we're a little bit in limbo of where we are, especially when it's contradicted by the discussion about new plots that we held at the start of the year.
And do you remember the discussion with Mr. Hall and my learned friend about what's being called the fallback position? Do you remember that, Mr. Hurton?
Yes, I do.
Essentially, the only way to secure provision of the plots is to grant the appeal. In your opinion, this issue of the cleared plots, the recently cleared plots, does that have any bearing on that fallback position?
It's a bit strange given that you would invest to clear the plots when the closure is being threatened as imminent if this appeal is unsuccessful for the appellant.
Could I ask you now then, please, to turn to Ms. Roberts' proof, core document A8. Paragraph 4.23, subparagraph 1. You can tell me when you're there.
I'm there, thank you.
And you can see here, Mr. Hurton, Ms. Roberts makes the point in this paragraph that there will be no loss of recreational amenity value. The allotments are not currently formally operational, operational, and with the exception of a small number of individuals, offers no recreational amenity to the community at this time. Do you agree with that conclusion?
No, I don't, and I hope we've demonstrated it to the Inspector, sir, at the visit on Tuesday.
And sticking with that point, what are your observations on the extent to which the wider local community, what I mean by that is beyond allotment holders and their immediate families and friends, what are your observations on the extent to which those people benefit from the allotments?
I think it's very clear in the fact that the Isleworth Society is representing the wider community, and how many people objected to the planning application, that the open space is beneficial to, not just the users, but the immediate vicinity, and a little bit wider in terms of St John's Residents Association coming and making a statement, Heppel Close residents coming and making a statement.
And how are people in the wider community accessing the plots?
Well, we have a number of things. We have an annual litter pick. We have an apple day where we pick the apples from the vacant plots. We have last Sunday, although it was a bit of a washout, we opened up the plots for a blackberry picking day, because there's lots of blackberries, as you will have seen on the visit, which are currently on the disused plots, which will go to waste unless we get pickers coming in and picking them and enjoying them. So Grace, who did a statement earlier, organised that, and is organising and looking after access and making sure everyone's safe when that happens.
So my final point on this, Mr. Hurton, might be helpful just to go to the ACV Tribunal's judgment. Again, this is core document G1. And it's paragraph 26 I'd like to look at with you.
Okay.
And we can see in this paragraph that the First Tier Tribunal here in 2016 acknowledged the wider public access to the site beyond allotment holders and the benefits to the wider community. My question for you, Mr. Hurton, is to what extent do the First Tier Tribunal's observations on public access and benefits in 2016 still hold true today?
I think it's very true. People are able to go onto the land and enjoy it. Not only allotment holders and their family, but also local people.
I want to move on now to discuss consultations with you. You referenced earlier a meeting you had at Syon Park with the appellant in September 2020. And you received an invitation to a consultation at Syon Park at that time.
Mm-hmm.
When you received that invitation, what was your understanding of the purpose of that consultation?
That we'd have a consultation about the allotments and the usage and the amount of land that plot holders would require.
How well attended was that meeting?
Fairly well attended. I can't say exactly, because if memory serves me right, there were two. I only went to one of the meetings, and there were two consultation meetings. But there was a good number of plot holders attending the one I went to. And
do you recall what was discussed at that meeting?
Yeah, it was a bit disappointing, because we were shown some very nice pictures of the proposed plan, but what the proposed plan was, what was set in stone, was the amount of land which was reserved for allotmenting, and that wasn't on the agenda to be discussed. So essentially, we were given a fait accompli with with only 31% of the land being retained for allotments.
Now, 3 months after that meeting in September 2020, the appellant produced a statement of community involvement. So if we could just go to that document, please. That's CDB 19. And the relevant paragraph I'd like to look at is paragraph 4.12 of that statement of community involvement.
Sorry, can you just give me the reference again?
Yes, it's CD, core document B19. If you're struggling, I can hand up the page to you.
It's fine, I've got it, thank you.
So we can see here at paragraph 4.12 that many allotment holders want to retain the existing allotment site, but agree to look for a compromise to secure a way forward. So, Mr. Hurton, during this pre-application stage, what sort of compromise solution did the Allotment Association have in mind?
Well, the compromise required making more land available, because what was offered wasn't sufficient for the current team of current Park Road Allotment Association growers to adequately grow the produce that they required. So that was how we viewed compromise, and we went back to the appellant to explain that. And we also did a survey of users' requirements, which we shared with the appellant to give them an idea of what compromise would be in our view.
It might just be helpful for the inspector just to have some references on that point. And so those references are at pages 38 of your proof. First reference. And we can see here at page 38, you've appended an email from the 26th of September 2020. And the second paragraph of that email starts with, there was a general agreement to a willingness to reach a compromise. But the biggest stumbling block is to provide people with equivalent space. Mr. Hurton, is that email reflective of what you meant by the willingness to reach a compromise with the estate at the time of the meeting in September 2020?
Yes, it is.
And you said that you did a survey with allotment holders to try and come back to the estate with that. If I could ask you then to turn just back 2 pages, page 36 of your proof.
Yeah.
There's an email there from the 18th of October 2020. What was that email about?
That was when we went back to the appellant to explain how many plots we would need to fulfill current requirements, not taking into account future requirements, but just looking at PRAA's members and what they required in order to find a compromise.
And so back, I hope it's still easily accessible to you. The statement of community involvement, that very same paragraph 4.12 we were looking at. We can see here that the feedback that the appellant has included from the consultations, and there's a list of things that they say was received in feedback. And we can see that the first thing mentioned there is a request for plot sizes similar to the existing. Is there any reason why, in your view, that was the first thing mentioned?
Well, that's the main thing. Essentially, everything came down to plot size, or more accurately, the very small plot size which was being offered, which then made everything else not a betterment and not very useful, because it took up growing space.
When you say everything else, are you referring to the facilities?
That's correct.
In that list. So, well, then those facilities that are mentioned in that list at 4.12, could you please then clarify for the inspector? I think you might already have so, but just the context in which allotment holders express support for those facilities.
Well, when we were asked about those facilities, could have either been one of 2 times. One is in the September meeting, when people were asked a variety of questions, but we hadn't had time to take in the full magnitude of the reduction of allotment spaces. So it wasn't until we got back digested that, had a meeting of the association, and came back with the letters, dated the 18th of October, which had just been discussed, and the one before that we could come back and have an effective put anything effective together back to the appellant. And the other time where that could come from would have been the meeting on the 16th of April, which didn't have plot sizes and land on the agenda. So as an association, we took the view that we weren't in a position to go to that meeting because it wasn't discussing the very major point of what we'd raised as a sticking point. And when we looked at that meeting, because the appellant gave some notes and did some minutes, which are also in my appendix at number 7, we didn't recognise anything that had been discussed, and anyone who we spoke to asked them among the association if they'd attended, and no one said they had. And Annie wrote to the estate and asked who'd attended that meeting to find out how many people had been and who'd responded, and we were never told.
And that list of facilities at paragraph 4.12, in your view, is the appeal proposal the only way in which the appellant could provide those facilities?
I don't believe the appeal. Having a successful planning application shouldn't need to be the barrier to provide any of those facilities for growers.
We've heard a lot about a community building that apparently was requested as well by allotment holders. And if we could just turn to Mrs. Roberts' proof, or her rebuttal proof rather, at paragraph 2.31 for this point. And just keep the statement of community involvement as well, please.
Mm-hmm.
So going to paragraph 2.31 of that rebuttal proof.
Okay.
I think it's a bit over the page. Yes, it's internal page 11 of that proof. And here Ms. Roberts says that a community, it refers first of all, PRAA say that a community building with electricity, provision of tables and chairs and associated amenity space is unnecessary, not an enhancement. However, Ms. Roberts then says a community space was requested through consultation with the allotment holders. And the reference Ms. Roberts gives there for that expression of support for the community space is paragraph 4.12 that we've been looking at. If you could turn that paragraph up again, Mr. Hurton, where in that paragraph, in that list of facilities, does it mention a community building?
It doesn't.
It doesn't. And at paragraph 2.30 of her rebuttal proof, Ms. Roberts says it is surprising that PRAA's position has hardened to such an extent when prior to the planning application being submitted, discussions between Northumberland Estate and PRAA were about reaching a compromise. Do you think that assessment of a hardened position is a fair one?
No, it's not. We've been very consistent in our position in that the land which has been reserved for allotment growing isn't sufficient for current needs, let alone future needs, and that we can't support anything because ultimately there's not enough space for individual growers to grow what they need to do. And so that's essentially the sticking point, and it makes any other consultation or any other betterment not very good. Not a betterment.
We've already discussed what compromise meant to the Allotment Association, and we've taken the inspector to some emails trying to demonstrate that. I'd like now just to consider what, in your opinion, compromise meant to the estate. And To do that, I'd like us please to turn to page 39 of your proof. And this again is email correspondence between yourself and the estate from February 2021 and January 2021. And we can see here, Mr. Hurton, in the first email there, the February 2021 email, second last paragraph, you wrote, "We are very willing to meet and consult, but the consultation has to be meaningful." And that email was in response to an email from the estate on the 25th of January 2021. So I'd like to look at about halfway down that email. I'm quoting from this email. "I think everyone is aware of the position that it is only through achieving planning permission that the long-term future of the allotments will be secured. If the scheme is supported, both by individuals and the Allotment Association, then it would be reasonable to consider your latest request for an extension in the current year." In your opinion, what does that email say about the estate's approach to compromise?
Well, it's a bit coercive, and it means we've got to do something that we don't want to do in order to get a lease extension.
I'd like to turn now to the final point, relating to the loss of open space. We've already touched on it slightly, discussing the facilities and the better or equivalent position. Now, I don't think we need to take too much time on this because the inspector has your proof. And sir, you'll be able to read from paragraphs 5 to 25 of Mr. Hurton's proof, essentially a bullet by bullet, blow by blow account, topic by topic of our position on each proposed facility and whether, in our opinion, they're equivalent or betterment. But I'd just like to just pick out a few points on that, if I may. And I'd like just to start with the proposed plot sizes. So we're discussing now whether this meets the requirement to be equivalent or better provision. So, Mr. Hurton, what are your views on the adequacy of the proposed 60 square metre plot sizes, taking account of the needs and experience of allotment holders?
They're not big enough to grow the range of crops that people need to, by any means, shape or form.
And I think you tried to illustrate this point at page 21 of your proof, where you include a diagram. If we could just turn that up, please. And if you could just help the inspector with what you intended to demonstrate through that diagram.
Well, sir, what that simply shows is a standard size allotment of 250 square meters, and put on there in the grey square is what a 60 meters squared plot looks like in comparison. And further to that, it shows how much space a small shed would take from cultivation, let alone what's needed for access and water butts and all the sort of peripheries or composting facilities if we're doing that on a personal basis on the plot.
So sticking with sheds then, you've just mentioned sheds. How are sheds currently provided for on-site by allotment holders?
Well, sheds are generally provided by the allotment holder because they can get something which is suitable to their requirements. Sheds are used for can be used for storing tools, storing, as we said before, storing pots, storing compost, storing produce. So, for example, onions can be stored there, which you harvest in summer and use through winter. But depending on your requirements, you need it for different things. You need a different shed. But alternatively, at present, a lot of people, like for example, in my case, I'll store my stuff at home and take it down because I haven't got space for a shed. So the various different people have different ways of doing stuff.
And how do the sheds that allotment holders currently have on site compare to the size of the sheds that the appellant is proposing to provide?
In general, they'd be larger.
So which would be larger, Mr. Hurton?
Sorry, the sheds which people have on the existing site, because there's a little bit more space to accommodate a bigger shed.
And so, taking that into account, then, what's your position on whether the sheds the appellant is proposing to provide are equivalent or better than what you already have?
Well, going back to my original point, it's not a betterment. It can't be a betterment because of the size of the plots and the percentage of the space which the sheds and access to the sheds would take up when you've got such a restricted growing area.
And final point on sheds, is there anything stopping the appellant providing these sheds currently?
No.
Just like to ask you then briefly, Mr. Hurton, your views on whether the communal storage space proposed by the appellant would constitute equivalent or betterment to what you currently have?
Given the small space which there is to grow, it would be surplus to requirements. When this time of year, when we have communal meetings, we hold them outside, al fresco, and during the colder months, we go to one of the local pubs, which serves perfectly well for us. And as far as communal storage for things, it comes fraught with a lot of difficulties, because if you store your tools communally and they're used communally and they don't get put back where, they're not necessarily there when you need them, there's nowhere to store your produce. And the same sort of things would apply if you were putting personal stuff in, like pots, seedlings, and germination trays, and etc.
And the community building we've heard a lot about, and we've heard that this would help people socialise and gather together more. Is it something you feel is lacking currently?
No. When people go to the allotments, they go there to do their work, to be working the land, to plant their seedlings, to be harvesting their crops, that kind of thing, which takes a significant amount of time. So there's enough time to say hello, etc., etc. But you're not going to be sitting around drinking that much tea, because you won't get the work done that you need to be doing.
Next topic, Mr. Hurton, composting. Now, we've heard that there has been a vermin issue on site, and the appellant links this to inadequate management of composting on site. What was this vermin issue about?
It was caused by one of the plot holders feeding the birds, which we've stopped, and the vermin issue's gone away.
Well, so was it linked to composting?
No, it wasn't linked to composting.
And proposal, the appellant's proposal is to provide a communal composting area. What are your views on whether this would be equivalent or better to what you have on site?
It certainly wouldn't be a betterment, because people have varying different ways of doing their composting. Some will buying pre-made compost from a garden centre. Others, like myself, will try and compost everything and use their own compost. But to get a good compost, you need to be careful on how you make it. So, for example, to get an adequate breakdown, you want to be cutting everything down to quite small pieces so it can degrade usefully. You need to have a mix of brown material compared to green material, and then you need to turn it once a year. And then on top of that, which I could see being a problem, is if you've got a communal plot, well, there's also issues about what you put in. Like, do you put in weeds and weed seeds? And different people have different viewpoints. So, for example, tomatoes which have died of blight, would you include that, etc., etc.? So there's all those types of things that are difficulties, but more so when it comes to using the compost and when it's ready, how do you split it up fairly with people? How's it organized? So it's certainly not as straightforward as having your own compost on your own plot and managing it as you want to do it.
The appellant was also concerned about the boundary issue, the security problems that they said have been occurring on site because of a lack of secure boundaries to the site. Mr. Harden, who's responsible for keeping the boundaries of the site secure?
Well, we believe the appellant is responsible, and as we pay rent for the normally would have paid rent for the growing, we and using the allotment sites, we think that's the least that can happen. And actually, the appellant has repaired the fence in the last year to where there's been some issues.
So, considering then your view that as landlord, it is the appellant who is responsible for keeping the boundary walls in good repair, to what extent then does their commitment to keep the boundary walls in good repair as a result of this appeal constitute an equivalent or a betterment rather?
It should be done as a matter of course, because that's part of being a reasonable landlord.
I'm getting through this now. Just want to turn to the issue of trees. And Ms. Roberts deals with this at 4.14 of her proof. Sorry, bear with me. I was looking through the wrong folder just a moment ago. And we can see here it's 4.14 subparagraph 9. Ms. Roberts says that existing trees and tree groups on site will be removed to avoid shade and other implications on the growing area, and that these existing trees render parts of some plots unsuitable for cultivation, and so their removal presents a better quality of provision compared to existing. My first question on this is, has tree cover and shade been a problem for allotment holders in terms of their cultivation?
When you're in full-size plots, it's quite useful sometimes to have a little bit of shade on the plots, and you can put your composting bins under it, etc., etc. I don't know whether the trees here are referred, well, where they're referred to. They have been a little bit of a problem going forward because they haven't been maintained where plots have been left vacant and the trees have grown up in the last 6, 7, 8 years. It leads to overshadowing of plots and a bit of a nuisance, but nothing which is insurmountable at this stage.
And in terms then of the responsibility for preventing the site becoming overgrown, helping to prune some of the trees, where does that responsibility lie?
Well, if it wouldn't be a problem if the plots were relet and there was full occupancy, people would be responsible for the trees on their plots. Where it becomes a problem is where plots have been left vacant and they haven't been managed because no one's there, because they haven't been relet and the trees are left to grow. And because we're in a conservation area, you need permission to trim the trees back. So it can become a problem.
And what are your views on the appellant's proposals about moving some of the mature fruit trees over onto the new plots?
I think it'd be very difficult to move any trees because the trees are, nurseries sell trees up to 2 to 3 years, because otherwise it's very difficult to get them to establish successfully. And no one's been investing in their plots for trees in the last few years because of the insecurity, which means that the only trees that are there to be moved will probably be about plus 8 years old, which means that the chance of getting them successfully moved are very difficult. That, along with when we've discussed or tried to discuss how things would work in terms of moving, we wouldn't know where the trees would go in the meantime.
It might be that I don't need to ask you about the soil issue, because I think that's covered quite comprehensively in your proof at paragraph 21. So if I could invite maybe the inspector just to take a note. And that's covered comprehensively there. I'd just like to discuss briefly then with you, Mr. Hurton, the question of accessibility. What I mean by that is the appellant's proposals in terms of parking and cycling on site. First of all, how close do most plot holders live to their plots?
Most people are within walking distance, but because of the nature of things, and some of the older growers use their cars, and some people come in on the way back from work. And currently we have 4 parking spaces outside the main gate. I think on the visit you'll have seen 2 cars parked up outside the main gate, and there's another space for a couple more if it's ever busy enough, which generally it isn't.
And do you feel there's a need for more parking spaces or cycling provision?
With what we've got now, it's about adequate with 4 parking spaces. With what's proposed, we're very, very nervous because the only talk about parking is that there's a disabled parking bay available, but none of allotment holders have a blue badge. So I don't believe, but I'm surmising that there'll be any parking at all for people wanting to not only deliver whatever they've bought from a garden centre or whatever, but then also park their cars while they do what they need to do with their with whatever they've bought. Like, for example, if you're bringing seedlings down from home, you not only need to drop them off, but you then need to plant them at the same time without having to take your car out of the way because it's blocking someone else. And the parking provision, well, it doesn't seem to be any parking provision in the proposal.
You said that most plot holders live within walking distance of their plots. Mr. Hurton, do you remember a discussion my learned friend had with Mr. Hall about conditions and essentially exploring the possibility of whether allotments could be re-provided elsewhere in the borough? Do you remember that conversation? Yes. So if it was suggested to you that allotment holders could just essentially go elsewhere in the borough to different allotments that will be re-provided, what is your position on that proposition?
Well, it'd make it very, very difficult and definitely unpreferable, especially given the transport and the congestion.
So I have 2 points for you in conclusion. The appellant says that securing the allotments for 50 years would be a benefit. What are your views on that?
It would be very nice to have some security of tenure, but if we had to sacrifice the amount of land that's required, it most certainly wouldn't be a benefit. And when you look longer term, and sir, you'll remember Milo, who came up and had a brief conversation, and one of his statements, he's 5 years old now, so in 50 years time he'd be 55 and he'd have to be going through all this type of stuff potentially, which when you think about it, it would be what's offered for 50 years isn't really sufficient. It should be in perpetuity.
Now, you've just said you would like some security of tenure, and of course we know it's the appellant's case, and they're saying, well, to get that, essentially the only way the future of these allotments can be secured is through the appeal. That's the appellant's position, and I'd like to explore this proposition with you in just a few stages. So the first is really about whether this is the only way to re-provide these allotments. And I'd like to ask you, the first question is, you've spoken about how you were served with notice to vacate and notice of possession proceedings in 2019.
Yep.
Has the estate acted on that?
No, we're still in occupation.
Would the allotment cease being local open space in the plan if this appeal is refused?
No, not at all. It would still be designated as local open space, and therefore it is my understanding that you couldn't build on it and develop it.
And do you remember conversations my learned friend was having with Mr. Hall around the question of compulsory purchase? And do you remember that conversation?
Yeah.
Now, I'm not going to ask you a detailed account of compulsory purchase. You're not a lawyer. It's not a question for you or the compulsory purchase side of things. But really what I'd like to ask you is, what is the Allotment Association's position on compulsory purchase as a realistic prospect if this appeal fails?
Well, we will explore if a fallback position is reached and the allotments are shut, we'll do everything that we can to keep them open, whether that involves a petition to try and explore that. That we'll certainly make sure that we get that done. And perhaps if development options are exhausted and it's vacant local open space, I don't know, it could be cheaper. Anyway, what is for sure is that if that fallback position is reached and the allotments are closed, we might not have access, but we certainly won't be going away, and we'll be fighting all the time to get the plots reopened.
I think that might be a good place to conclude. Thank you very much for your evidence, Mr. Hurton. I have no further questions. The inspector might, and my learned friend certainly will. So if you could stay where you are.
Mm-hmm.
I'm pouring myself some water, Mr. Hurton, but do you have some? And if you don't, do you want some?
No, I do. I'm fine. Thank you.
Good, okay. So good afternoon to you.
Good afternoon.
So the first thing I wanted to ask you about is the asset of community value judgment, which I believe you have.
Yes.
That's CDG 1.
What paragraph were you referring to? Sorry.
So you've got that in front of you. That's good. If you look at the first paragraph, I want to agree with you. The effect of the listing. Are you able to help me with what it actually means for an asset of community value to be listed? And if I make suggestions to you about what it means, are you able to help with that or not?
Potentially. Have a go. Let's have a go.
Okay.
Yeah.
So, I mean, what I suggest to you is that the effect of a listing is that it delays any sale in broad terms.
Yes, and I think it also recognises the value of the importance of that space to a local community in broad terms.
Well,
as well.
I'm asking about the implications of it, the effect of it. And so the first thing is it delays any sale. And the second thing is it confers, doesn't it, a right to bid to a community, not a right to buy. That's right, isn't it?
I don't know it in that much detail to be able to confirm.
Well, you can see it from paragraph 1 of the judgment that you've been asked to give evidence about. Paragraph 1 under the heading legislation. But if that's not something that you've read, that's fine.
I haven't read it. I know the basics of it.
Okay, fine.
But I don't know the detail.
All right. Now if you look at the top of it, so look at the front page, you'll see that it was heard at York House in Leeds and it was decided without a hearing.
Yep.
And at paragraph 11,
yep.
The judge said that the parties were content for the appeal to be decided without a hearing, and in reaching a decision, then it was having regard to written evidence. So the decision was based on what the judge was told in evidence, wasn't it? Without a hearing.
Yes.
Yes. There was reference, I think you've been brought to vacant plots. What we can agree, I think, is that it didn't mention, did it, uncultivated plots. It made no reference to that, as I understand it.
It says vacant plots.
Yeah. And both vacant plots and uncultivated plots are shown in the design and access statement, aren't they? And you've just looked at that with Banana Friend.
Yeah, I have looked at that, and I've questioned the methodology on getting those results.
As I understand it, the methodology was walking around the appeal site and talking to those who are there as well. So I'm sorry, but was there some other methodology which you were suggesting would have been better?
Yeah, I would suggest that it would be sensible to liaise with Park Road Allotment Association and go around and have a discussion with people there, because I don't understand that to get everyone to be able to have a conversation when people are down at the allotments. They're not down at the allotments all at one time, so you'd have to go down an awful lot to be able to find the relevant people on the relevant plots. And I bring your attention to plot number 26, which is Tim Rugg, who we heard from, who gave a statement 2 days ago, and also gave a statement on behalf of his of Cleve West, whose plot is number 26, which is marked down as vacant. And he's told me that he's been paying rent for 20 years on that plot.
Yeah, I take the point. I mean, I'm not able to contradict it in relation to one specific. I wasn't there at the time, and I can see that it's marked as vacant. So
that gives you an example, and that puts things from my perspective.
Yeah. Okay. And so, as far as the wider public access to which you make mention and benefits to the wider community, as I've understood it, isn't this a locked site? Isn't there a gated access to the site?
It is a gated access, right. But for example, on last Sunday, which was in all that rain, so we didn't get many visitors, Grace advertised the blackberry picking and stayed in her car because of the rain and allowed access for, unfortunately, because of the rain, just two hardy souls that came to pick blackberries. But we're going to do that again so that people can make use of the blackberries, which otherwise would go to waste, because they're in proliferation on all the unlet plots.
I see. Okay. So we turn to your proof, if you would, please, and to the appendices to it. Going to look at some of the correspondence that you've brought to the inquiry's attention. And page 31, please.
Yep.
This is a letter to you. Do you know whether or not like letters were sent to others, or similar letters were sent to other people?
I believe so, yes.
Yeah. Okay. And so this is in March of 2019, isn't it?
Yes.
And the decision letter, as I've understood it, was November of 18.
The decision
the
of
appeal decision letter,
yes,
was in 2018. So this is after the previous inspector's decision.
Yeah.
Yeah. And the author recites a little bit of the history. Up till 2015, the council had a lease of the allotments. In 2015, we decided to take back responsibility to progress our plans to develop the land.
Yeah.
Yeah. And is that consistent with what you'd understood to be their position at the time?
Yes, there's been one planning application gone in, and that got rejected at by the council and also at public inquiry.
So what they've said here is quite consistent with what your understanding is, which is that they've been perfectly open about development aspirations for this land since as far back as 2015.
Yeah, I agree.
And what they then did in terms of those who were using the site was to grant short-term tenancies, and that was only ever pending bringing forward of development, wasn't it? It was the
I
purpose of short-term tenancies was so as to allow so that development
well,
could take place.
does it need to be a short-term tenancy right now in 2023, and we're still going around the same stuff? So, to my way of thinking, the short-term tenancy is the appellant's decision because they're the owner and the manager.
That's it.
That's just what we have to work with.
You don't like it, and you didn't agree with it, but that is why they did it, isn't it?
It's not for me to say, is
I
it?
see. Okay. And what they then did was give notice, didn't they? Pursuant to this letter, it was, I think, attached, wasn't it, or provided with it, which was to terminate the arrangement on site. Yes?
Yes.
Yeah. And then the period there came to an end, I think, on the 31st of March, 2020.
Yes.
Do you see that? The last line?
Yeah.
So it's a 12-month notice period. Yes?
Yeah.
And what then happened was that you asked, I think this is you or somebody on behalf of the Park Road Allotments Association, perhaps not you, but somebody on your behalf, wrote to one of the estate's advisors and asked for a new license in light of COVID and other factors. Yes?
I can't specifically remember.
You've got it here.
In whereabouts you're referring to?
It's the email of the 30th of March. This is your document.
Oh, right, that's fine. Sorry, on the next page. Yeah, fine.
So the request, in other words, the request was made in the March of 2020. He said, well, look, in light of COVID and other factors, could we have new licenses, please? And the answer was no.
Yeah.
And that presumably was very unpopular.
Yes.
Yes. So even despite the unpopularity of that decision, that policy of not granting new licenses they persisted with it, didn't they?
Yes.
Yes. Now, I had understood just from some of the correspondence which had been included that there was some uncertainty about whether or not the licenses had come to an end. But just listening to the way in which questions were put and you answered them today, I think that's a matter which needn't detain us.
Well, from our perspective, there is a little bit of uncertainty because we are still in occupation. And we were invited in for a meeting about clearing 2 plots with a view to issue new licenses, which haven't been issued, but all the clearance has been done. And we've spent quite a lot of time discussing that as committee members.
Yes.
On behalf of Allotment Association and growers. And I think no further progress has happened on that. And I think there are a number of people who've been disappointed about it.
Well, hasn't the clearance taken place in the south of the site?
In March, yes.
Yes,
and we're now in August.
Isn't that where the planning application, the appeal application, which is in front of the inspector, proposes a new plot?
Yes.
Yes. So isn't what's happening there in good faith preparation in case planning permission is granted so as to make the plots available?
That most certainly wasn't put to us like that, and it would seem counter to what was discussed, because it was very important to try and get it through and get the plots cleared ready for this year's growing season, and that was put to us at the time when we had that meeting in January, and we all worked very hard to make the time to get an agreement so that the estate could go back to the council and get permission to clear the plots, because there were saplings and trees on there which needed permission to do that because it's a conservation area. And so before you do any pruning or anything like that on substantial trees, it needs to be discussed and agreed. And then that came through. But then by the time the contractors came to do that, we'd missed the dry window in February, and it was that really wet March, and it made a heck of a mess all the time to do that, and a mess of a track up and down to get it cleared.
All right. Well, I mean, my understanding is that that's consistent with what's being proposed.
No, that's incorrect. They were definitely cleared with a view to getting them into growing this year.
Well, I mean, I can't take that any further. It's not consistent with my instructions. Let me move on, though, as I have to. The current requirement that you made reference to, which evidently you feel entitled to have met. You said you required more land and that a compromise would necessitate the provision of more land. Yes?
From our perspective,
yes.
Yeah, the plot size is too small
Yes.
of the area which is reserved, which I think is, excuse me one second, of the 29% remaining, which is 3,393, there's only 2,280 meters squared, which is cultivatable because we've got attenuation tanks from the new development, which have been put in the reserved area for allotments. And then there is also shading areas from mature trees, and there is also the proposed communal building. So there's quite a lot of the space which can't be grown on them.
Yes, understand.
As well as the small plots.
Understand that. Getting into that level of granularity is not at the moment the subject I'm on. So
okay.
What I'm wanting to understand is first that your position as an association was not to say that you opposed in principle the redevelopment of part of the site. That wasn't your position, as I understand it.
We were happy to have a discussion and a consultation, but there was no point having that consultation because all we were given at the first meeting in September 20 is the fait accompli showing the boundary, and that was set in stone.
I understand that was a hard-edged position for you, but just want to understand this, that your starting point was not that there could be no development of this land at all. Your starting point was that there could be, provided that you had what you felt were your requirements met.
Yes, there could be some middle ground for sure.
Okay, you should. So, yeah. And so just wanting to understand, if you like, the difference between us in terms of the compromise. 0.35 of the 1.17 hectare site, it's in the statement of common ground, I'm just reading from that. 0.35 of the 1.17 hectare site is set aside for allotment use as part of the planning application. Now, the compromise you had in mind presumably involved more of the 1.17 hectare site than 0.35 of a hectare.
Yes.
And am I right in thinking that the area that you had in mind was more like 50% of the site?
Well, when we went back to members, that it worked out about 19 plots. So 19 plots of 37, 38 is about 50% of the site. It doesn't take into account any future requirements, but for what we were discussing at the time and what we went back with was about 50%. So yes, totally agree with you.
Yeah. So putting it into sort of hectares, the position that you object to is 0.35 of the site being set aside for allotment use, and what you would have been prepared to compromise on was 0.585, because that's half of 1.17, around about.
Yeah, at the time that would have given everyone who were members and who were at the meeting and who did the survey adequate growing space.
Yeah, I see. And you referred in your evidence to a breakdown in communication, and there was really, I think, a breakdown in negotiation. If you look at page 39 of the bundle that you've given us, is your email, page 39. What you were not prepared to accept is that there'd been a negotiation about the amount of land provided.
Yes.
And in those circumstances, you were then saying, well, having a further meeting about this is pointless because all the details don't matter to us. It's the amount of land available.
Yes.
Right. And so, I mean, I hear all the criticisms about the various facilities provided, but it seems to me that the underlying objection is really not about the detail, it's really about the amount of land.
Yeah, absolutely, because it wasn't sufficient for people to grow what they needed to grow to make it meaningful to have an allotment.
Well, I hear that, but you'd appreciate our position is different.
Mm-hmm.
Yeah. And in terms of, if one thinks about, I mean, breakdown communication, yes, because of course you don't carry on talking, but really a breakdown in negotiation because your parties are just too far apart on that.
Mm-hmm.
If one's looking at a starting point in negotiation, really the first port of call is what is the legal position of the parties? What are they actually entitled to? Not what they feel they're entitled to, but what they're actually entitled to. Isn't that right?
Can you say that again?
Yeah, sure. In a negotiation, you've got to think, well, what is the actual legal position of a party to start with? What are they entitled to? So contractual negotiation, for example, what are you entitled to under the contract? What do you say your legal position is?
Well, in a negotiation, you put your position down and then you have a discussion about it.
But you've got to have some basis for negotiation, haven't you? I mean, if here you are growing on a plot which was never statutorily protected land, was it?
Appreciate that.
Right. And therefore, the only license that you ever had was license of a private site.
I appreciate that as well.
So that never gave you any security of tenure beyond the contractual period in the notice.
Yes.
Yeah. So although you're aggrieved about not getting a reprovision, in fact, in legal terms, you're not entitled to it, are you?
Well, we are aware of that,
Right.
but we are also aware that it's local open space, and we're also aware as local open space, it's beneficial, irregardless of whether we're on that land as allotmenteers, but it still has the benefits in terms of ecology, in terms of space for local residents, etc., etc.
Yes, and I think that does reflect the negotiating power, which is your ability to object to the planning application. We're
objecting to the planning application because what was presented to us wasn't adequate and sufficient, and when we went back to have a discussion, we were told there was no way that could be moved. So what's been offered isn't sufficient for current growth requirements or for future provision. So therefore, we cannot support the planning application.
So, I mean, I think we've agreed that the negotiating position doesn't come from law. It's from your understanding of the planning process and your ability to participate in that.
Well, if that's the way you want to view it, that's the way you want to view it.
That's how you viewed it. When I asked you the question, that's what you said.
It's not a negotiation tactic. It's where we are, and what's been offered isn't sufficient as far as all the members of the Park Road Allotment Association. And my job as chairman is to represent that. And if that involves opposing the planning application because it's not sufficient, that's what it is.
I see. That's very clear. Thank you. And Mr. Barnes did refer, didn't he, to that position in terms of objecting to the planning application in his letter, to which you took exception. I
didn't take exception. I felt it was coercive in the fact if you don't accept what we're offering, you'll be left with nothing. So it's a bit of a double bind, isn't it? You're either forced to do one thing which you don't want to do, or you lose access to the site allotments. But as it was, what's been offered and what we all thought is 60-meter square plots by the time there's a shed, etc., etc. There's no point investing the time in such a small area to cultivate such a small area, which is why everyone voted to stick to their guns and be where we are and oppose the planning application.
I see. Okay, look, just one last point. On the is it fair to say that opposition to the appeal has galvanized the allotments? the association?
Oh,
I mean, has it sort
what's-
of invigorated the association?
Not really. We have the same issues as we've had ongoing since 2015, when unfortunately the lease passed back from the council to the estate, and from 2015 the development potential of the site that you wanted to explore has always been hanging over our heads, and the fact that it's non-statutory and that you might close it, it's what it is, and we've had to live under that threat for the last 8 years.
I mean, because you'll appreciate from the estate's point of view, it contrasts the position with when it took the activity on the allotments can be contrasted with the position when it took back responsibility in 2015, when, as it understood what it saw, it was actually overgrown and underused.
Well, I disagree on that, and the ACV says that that 78% of the plots were used, and I think that's the best. I wasn't involved in the management in terms of being chair at the time.
Yeah.
And as you said, you went about, and so the best thing we can go on is that independent survey.
I'm grateful. Thank you very much for your time this afternoon.
Okay, thank you.
No re-examination, sir.
Just a couple of questions from
Yes.
me, please, Mr. Hurton. Firstly, in terms of the layout that's suggested for the proposed allotments, do you have any comment on the layout?
Yes, we did have the comments, but we hadn't really been very vocal on it, purely because of the space. But as far as we're concerned, we had difficulties in that the attenuation tanks for the runoff, to slow the runoff, essentially the reservoirs from the development, were in the bottom, in one of the corners of the site, and I can refer you to our overlay appendices. Sorry, 1 second. I've got too many pieces of paper. But the overlay. Number 3, appendix number 3, which shows in blue.
Sorry, do you have a page number for that?
Yes, sorry, number 20. Thank you. The blue area shows the attenuation tanks, which are the reservoirs from the runoff to slow the water going down the drain, and they're on the side reserved for allotments, and it's going to make, well, it takes potential two plots out of production, and runs the tanks down the path. And that's an issue of contention. Another issue of contention, which is the damage that will be done to the soil structure of the heavy machinery, which is going to be needed to go in there to dig those reservoirs and to take the spoil away, and also the drainage which runs right across the site from to the drain in the bottom south corner. And you can see that on page 20, highlighted in brown. There's also the roadway which we went down to view the plots at the bottom corner, which are being cleared, which is a hard standing which will need to be removed, and we don't think that will do the growing. It runs straight down the plots, and that's not going to be particularly good soil after it's having hardcore on there. And I presume there's no barrier between the hardcore and the soil, so it'll be very difficult to mitigate that. And of course, down there we've got a couple of mature trees, and the mature trees on the southern side, which will provide quite a lot of shade to the growers there on the wall side, which we talked about, where people had had their storage or left it, had a little bit of wild area for the for nature.
So that's along the southern boundary.
That's on the southern boundary with the wall which divides the children's play area in the churchyard. And essentially, the cumulative amount of all that means that of the space which is reserved, which I calculated to be 3,400 meters squared, only 2,280 meters squared is cultivatable, which is 38 times by 60, or the plots which are marked in there. I can't remember the exact maths.
Okay, thank you, Mr. Hurt.
Is that the only question? Or do you have any?
Yeah, that's fine. Yeah, you can step down. Right. Yep.
So, just as enthusiastic as I am to sit late, there is a site visit scheduled this
Yes,
evening.
I know.
So,
yeah. Excuse me. Also, the pens normally it's 5 o'clock at a push, 5:30. So, yes, and I've got to look at the allotments as well as the heritage assets. So I think we'll best call it a day there. I'm hoping we can start at 9:30 tomorrow morning. Okay, good. That'll be helpful. So we'll call it a day there. Just to recap, I would like 20 minutes, half an hour on my own at the allotments, and then I'll go to the heritage assets at the Scion Park. I'd rather do it in that order because I don't know how long I'd be in Scion House, and therefore I can't know how long to give for unlocking the gate, etc. And daylight. Well, we should be right at daylight. Yeah.
So just so we can arrange for keys and so that it's open. Do you have an idea of what time you'll arrive at the allotments?
Well, I'm on foot, so I did it in under an hour last time, but I will have to change my footwear,
of course.
And suit trousers for obvious reasons if we're going to the allotment. So if we could aim for 6:30 on the allotment, and then if I could, I think I've got a helpful map. So if we say 6:30 at the allotments, by the gate that I came in at last time, which I think is down the track, just before the avenue of pollarded limes that leads to the church. And then so at 7 o'clock, if there's only a couple of minutes walk between, isn't it? Then go to the lodge, Porter's Lodge, which I think is number A on my site plan.
To be met at the Porter's Lodge, yes, of course we can do that. Yes, I mean I suppose I assumed it would be at the gate, but Porter's Lodge is fine, isn't it? Yeah, that's fine. In terms of who will accompany you on that part of the site visit at Scion House, it will be Mr. Bridgeland for us.
Okay.
I think that's it, isn't it? And
well, I do need to be accompanied by.
It'll be Mr. Hall.
Mr. Hall, that's fine. Okay,
so
right.
Are we saying Porter's Lodge at 7 o'clock? Is that?
Yes. Yeah. Sorry to disrupt your evening, Mr. Hall.
So Miss Casey would also like to attend.
That's fine. I'm quite happy with that. Okay, right.
obviously, that's fine. Is there? Just forgive me. Fine, thank you. I'm not sure if it's a today point, sir, but you did ask for the some more information about the relationship between Viewpoint E and the World Heritage Site.
Yes.
So
yes.
can I submit that?
Yeah,
Thank
absolutely.
you.
Yeah, that'd be helpful. Thank you. Okay. Thank you. Yeah. Okay, so we'll start tomorrow morning then with Miss Casey at 9:30 in terms of examination. Okay.
So I'm not entirely sure where offline discussions got to in terms of the ecologist.
Sir, I did discuss this matter with the appellant. Certainly from our perspective, we're happy to put in some written questions and feel that we could deal with matters adequately in that way. In your hands, sir, as to how you'd like to deal with it, but we would be happy to provide, for example, a list of questions perhaps next week. And then perhaps, sir, if you find that useful, it may cover some of the matters that you would like to cover. So we're happy to produce first draft of questions and provide them to you by next week.
Okay, thank you. I'll have a think about the timescales, but I'm happy to proceed on a written representations route for that particular issue.
I'm grateful, sir.
Yeah, okay. I'll need to give a bit more thought to the timing and procedure and when I ask questions as well. So yeah, okay, right. Okay, so I'm going to go to the allotments on my own through the gate, and then I'll meet various people at Porter's Lodge at 7 o'clock. Okay, thank you. So the inquiry's adjourned for the day. Thank you.